H. Government. That's it.
I apologize beforehand for mentioning today, Lordship, but it's just only for the convenience of the court, Lordship. May I, with the leave of Honorable Justice Chatterjee, mention the OBC matter? My lord, I appear for the West Bengal Backward Classes Commission. My lord, Lordship knows that Lordship had fixed this matter on the 18th of November, so the list is due to be out. In the meantime, Lordship, the Supreme Court has passed an order. My lord, if Lordship...
Why you showing that order?
Malad, it's
For
because
what?
Malad, it's only to say that the Supreme Court has passed an order saying that the Supreme Court itself wants to hear the matter. In time, it has in the meantime, it has
So
requested the High Court.
if we sit, you remind us. Don't mention.
Lordship, grateful.
I will be presenting this statement.
Malad, as my lord.
If we sit, you mention.
Lordship. Okay. I apologize, Lordship.
Yes.
Your Lordship, kindly leave to mention, my lord. Yesterday, my lord, I mentioned the matter. Your Lordship asked Mr. Chatterjee to bring, my lord. Then your Lordship was, my lord, hearing the matter. Your Lordship, my learned friend mentioned yesterday. Your Lordship fixed it on 19th. My lord, 19th, my lord, we have some difficulties. If your Lordship take it up, my lord, subject to your Lordship's convenient, 20th. My lord, subject to your Lordship, my lord, permits your Lordship diary, my lord. Notice, are
Month 15 to 7. 20.
I'm grateful, my lord, deeply.
My lord, my senior Mr. Torun Kumar Das, he is like in courtroom number 10. I praying for a short pass over, my lord.
Who sits in courtroom number 10? Which honorable judge sits? You have been asked to take time. Have you ascertained who sits at court number 10? Take the list. Take the list and find out the name of the judge. All in every case, we have a indifferent attitude. ক্লার্ক এসে বলবে ক্লার্কের কথায় নামবে
My lord, Honorable Justice Smita Das de.
So which is superior, division bench or single bench?
My lord, there is also item number 1 is there.
My lord, in this matter, about the state, there is a direction upon the state, my lord, to supply the calculation sheet from the DI so that the petitioner can deposit her amount for getting my lord, family person. It's a CPF to GPF. So, my lord, we have not yet able to calculate the. Kindly, I'm praying 2-3 days more time. By Tuesday, my lord, we will deposit the calculation sheet.
th করে দাও 20th.
My lord, on last occasion, your lordship pleased to pass the order on 25th September 2025. There is some mistake, my lord.
Remind when it is taken up.
Yes, on 20th.
20th.
Come on 20th.
My lord.
20?
But a petitioner could put the
28. On 20th.
Deeply.
Yes.
मतलब non-prosecution. Ma'am,
Mr. Pal, Lalit advocate appearing for the appellant.
এই ফাইলটা দাও।
Regulation. Respondent, petitioner respondent.
এটাই আরে ওই অর্ডারটা যে সাক্ষীর ওই নন্দলাল দাসের আপনি যে সরকার পাঠিয়েছেন এটা
Is your other side? Was
it
before a difference bench.
was before Justice Shen initially. In fact, there are series of matters out of which already one matter has been decided by Justice Sen. Can you have a look?
What? By us?
No, by Justice Sen. While Lordship was taking up the serial. In fact, if your Lordship kindly have a look.
ধরে দিতে পারে।
Of item number 3, Lordship will find this matter initially when was taken up, where this was indicated that these issues are already covered. Lordship may have a look. Since the whole issue has been settled up to Supreme Court.
Order complied with. Single judge order in that case was complied with.
In this matter? No, not yet. We are on the contempt stage.
What is the matter about?
Matter is regard to the hostel mess workers of institute, whether they should be treated as a staff of that institute or not. This was the issue. Initially, there were matters before this court wherein orders were being passed in our favor. This was tested before the division. We succeeded over there. Retested before the Supreme, once again succeeded, and those matters were already complied. And that Lordship will find indication from the order itself, even of the order of the Judge Single. Therefore, when this matter, Lordship was.
What was the order passed then?
In this matter? Gলাটা ফেটে যাচ্ছে। Oh, here. Contempt কেন ইয়েটা দে আর অ্যাপ্লিকেশনটা দিন না অ্যাপ্লিকেশন অ্যাপ্লিকেশন
Mr. Banerjee, their presence will be required in such case. Tapun Mukherjee appeared
Mr. Tapun Mukherjee appeared in the earlier matter.
when this order was passed on 7th July.
Yes, Mr. Mukherjee appeared.
No, the order impugned, which they impugned before this court, that order also might have been similar to the order impugned.
Same. In fact, Lordship, kindly have a look at the order last passed by Justice Sen in this matter, this Roshomoy matter. Kindly have a look. In fact, this was indicated before the court. His Lordship was of the view that these orders will covered by this judgment. They prayed for an accommodation. Lordship will have a look.
Who prayed for it?
In fact, Lordship will find the same on the file. 17. This order will cover by match 79. 79 নয় এইখানে লেখা আছে ওটা last order will Lordship will find an accommodation prior to that. I hope Lordship has found it. আরে ওটা ওখানে
Mr. Mithro, he says that identical issue has been decided.
Identical issue has been decided without considering another coordinate division bench judgment. That is only my point. This case is not covered as other order has been passed. That is why the division bench considered and directed not to proceed in the contempt. This is the order of this case. These three
this is
cases.
absolutely untrue.
I have
Absolutely
satisfied-
untrue. Lordship, kindly have a look.
Wait.
I have satisfied the division bench earlier. It is true what my learned friend has said, that there is a coordinate bench judgment.
Which stood tested and implemented even up to appeals court.
Where is that order that they will not proceed with contempt?
কোটাতে আছে রে?
এটাতে নেই
Okay.
কারণ এটাতে তো
Three appeals are there.
in fact those three
President-
appeals appeared on the very first day. Court said
You took time to
Yes.
consider whether these appeals can be disposed of in terms of that Nandolal case.
Yes, but that is the first order. But
no,
this
this is the last order.
বলতে দে।
Wait, Mr. Banerjee.
There are other two cases and order has been passed. আছে তো এই দুটোতে 3 থেকে 6 একটু দেখি।
Have you applied your mind?
Yes, I have applied my mind, but today that I don't have the brief with me. That is the difficulties.
Mr. Mithro, this was adjourned way back on 18th.
Yes.
Matter is appearing in the list.
But your lordship kindly adjourn for 2-3 days. I shall satisfy. Thereafter, your lordship will pass orders. There are division bench order considering the same facts allowed and said, my lord, they cannot be, my lord. This is kind of a regularization of service. My lord, this cannot be done. There are two set of candidates. One is as a sponsored candidate, another is a technical education candidate who are governed by the rules. My lord, these cases are governed by rules.
Then why didn't you take that point before the coordinate bench?
Coordinate bench, but unfortunately that point has not been taken, or it has been taken, my lord.
Preferred
It has not reflected in the,
Have you preferred review of the said order?
no, my lord.
Then, Mr. Mithro, how can we entertain your prayer?
Another division bench order we have filed a
Then
review.
We have to distinguish the division bench judgment. You are asking us to pass an
Consider
order,
that judgment, my lord.
consider another judgment and reconsider the verdict in the other matter.
No, my lord, those are different. There are two set of employees. They are
Yeah.
relying on a same circular, but that is not applicable. Relying on that circular, another division bench has dismissed the, my lord, case of the writ petitioners. And that SLP is also, my lord, dismissed. Against the writ petitioners, SLP is also dismissed. That is why, my lord, we have to satisfy. It is not a division bench case where the writ petitioners therein has failed. But thereafter, they have approached the Supreme Court and Supreme Court has confirmed the order. Let us, my lord, come up with another 2 or 3 days. I shall satisfy you.
Place the issue in a nutshell for once. I think his queries can be answered in one go.
Your section 5 was allowed.
Yes, my lord.
This stood allowed. And
Satisfy us, we will keep it as to be mentioned.
My lord.
Keep it as to be mentioned. You tell us how it is distinguishable. Otherwise, same order will cover this one.
Your lordship can be fixed on Wednesday then, my lord. Kindly.
Whatever he is on,
The matter was last heard by coordinate bench of this court on 18 July 2020.
কত অব্দি হলো মানে
3 থেকে 6
তিন
থেকে 6
তিন চার পাঁচ ছয়
ঠিক আছে।
seven, ঠিক
That transfer, that medical ground.
No, that is fixed on 17th. My lord, as per your lordship's last order, this matter is supposed to come on 18th. So it
This
was
matter.
this matter, along with other matters. But in between, there was
Along with other matters mean that transfer
no.
medical ground.
No. This is different. These are the job losers, untainted candidates. Now they participated at the upper primary level
Yes.
recruitment process. Job losers, untainted of that 26,000 Supreme Court's order. They were untainted job losers. Now, when they were not in service, they applied to participate in the upper primary. This present, your lordship is hearing this Rajiv Brahmo upper primary, that upper primary. At that point of time, they were not in service, they applied. But in the meantime, they obtained their service at the secondary level, which they have lost today. Now, when through passage of time, when at the time of interview, the authorities for upper primary, they asked,
New selection process.
not this one, secondary selection, it's upper primary, Rajiv Brahmo's upper primary.
Rajiv Brahmo.
Rajiv
Oh,
Brahmo's
acha.
upper primary.
In which we allowed
Yes.
appointment to 26,000.
Yes, and 1,400 an order left out. That is your lordship aware of. I'm not in that. My case is not that.
Very good.
My case is this. When I applied for upper primary, I was not in service anywhere. Subsequently, through passage of time, I got my appointment at the secondary level, which 26,000 today has gone. Now, my lord, when we are in-service teachers at that point of time, the upper primary authority called this SSC called us to participate in the upper primary level. We went to
Upper primary of which year?
upper primary of this Rajiv Brahma's upper primary, that upper primary.
Yes.
First, what happened? First, form fill up of upper primary was started. Then the secondary, after that, secondary came. But secondary completed before upper primary. If I'm, may I try again, my lord?
Don't be so detailed. In
Yes.
a nutshell, tell us.
In nutshell, my lord, first,
You participated in the upper primary selection process,
Yes.
which culminated in an order of appointment to 26,000. That is upper primary, you
Yes.
participated.
Yes, but we were not allowed to participate. That is my issue. We were not allowed to
At the
participate
time of
interview because they said you are already in service. By that passage of time, I got
in service means you were serving in what post?
I was serving in the secondary, this 26,000 where we lost our service. That is what I'm saying. Through passage of time, secondary took place previous to the upper primary. First, recruitment notification of upper primary was initiated first. Yeah, upper primary. Upper primary. In between, secondary notification came up. We applied. We
And
got,
you got
service. Yes.
Then what?
Now we got our service and we took our service. We joined our schools. Now, when the upper primary process was going on, at the time of interview, we were called. We went there. They said no, you cannot participate because you are already in service. Secondary service we are already in. They said no, you cannot. But at the time of application, we were not in service. Now, what happened? We accepted that very well. If you are not allowing us, we are already into a service, we will not participate. We retracted because, my lord.
Now what happened?
Now, what happened, my lord? At the counseling round, we found in-service candidates have been given appointment. When we were not allowed to participate for being in service, and there was no bar in the rule, nowhere. Only in the notification.
How can you bring up that issue at this belated stage?
Yes, my lord. Why? Because at the belated stage, at the 9th round of counseling, which happened a few months ago, where we found that these kind of candidates have been given appointment. Then what mistake we committed? We were being honest to the authorities that yes, we are in service.
Honestly, you should have approached the court earlier.
No, we accepted that.
When you accepted that appointment, you were at your own risk and peril.
Yes.
You have done.
Yes, but now we found that at the belated stage, now these kind of candidates have already been given appointment behind our back. We did not know this. Now we are the job losers as well. Now we have lost because, my lord,
have you implemented any person, any private
no,
person?
we have, yes, we have given the records because we are not after their service. Our only contention is if you have given to them, why to deprive us? We accepted your decision.
You have been deprived in 2015. You were not allowed to participate.
Yes, but 2025, they are giving appointment today.
So you accepted that non-participation. You accepted.
Yes.
Next, you went to the upper primary. Ultimately, upper primary was held. In the upper primary, the final order was passed. Then you came up and then you are coming up.
No, at the time of counseling, we found that this kind of, we also come within the same category. We have been deprived at that point of time. Now they are being given appointment despite being in service. And my lord, we were not in service when we applied.
You are not answering our query.
My lord, kindly, may I just answer you?
How many times we will say?
No, I have understood that I have come at a belated stage. Possibly that is your lordship's query.
Yes, how do you explain that?
I'm explaining, my lord, because it is not at the belated stage. It is because, my lord, it happened subsequently. It happened in late at 2025. At that point of time, we did not know. Now the subsequent counseling processes kept on going.
Have the affidavits been filed?
No. There are 3-4 matters, my lord. In none of the matters, affidavit has been filed. I would have not.
And in the matters fixed on 18th, affidavit filed.
None
that
of
also not
none
filed.
of the matters. None of the matters.
Commission is a party here.
Commission is the answering respondent.
Commission is answering.
Commission is answering respondent.
Then who appeared? You appeared.
I appeared in the date, so it appears, but
Affidavit গুলো
services.
হ্যাঁ
These are not
আগের বার
being
দাঁড়িয়েছিল
engaged.
there was a last
Get yourself engaged then. Similar matter.
No, no,
This is not the difficulty, but right now I'm not in a position.
yes.
Oh, you appeared.
17th September you appeared.
The last day I
আপনি ছিলেন
yes, then my juniors have not marked it.
এটা এই অর্ডার তো
হ্যাঁ
মধুমিতা না না না,
কিছু অর্ডার দিয়ে দিয়েছে
এটা অন্য
ছিলেন না আপনি ছিলেন
এটা
না
মধুমিতা যেটা 18 তারিখ
আচ্ছা,
রেখেছে।
এটা আপনি ছিলেন না
আচ্ছা আচ্ছা
In any of the matters you have filed affidavit.
I'll have to check what is the matter I am.
ফর্নেশন লিপ্টন এই ম্যাটার ওই যে আপার প্রাইমারি যে
বলুন না ওটা
সার্ভিস তোর বুঝতে দেয়নি
অর্ডার
এগুলো
ও।
এফিডেভিট দেয়নি এখানে তো অনেকগুলো একসাথে ছিল লিপ্টন লুথফর্নেসা এগুলো
On 18th again it will be adjourned.
Kindly fix a date, I will check. That
What you will check? এই অর্ডারটা দেখো। This opposition you have to prepare না। এটা কমিশন একটু
হ্যাঁ
এটা সিমিলার অন্য মামলা এটা
হ্যাঁ?
এটা না এটা সিমিলার ম্যাটার এটা সিমিলার ম্যাটারে আপনি অ্যাপিয়ার করেছিলেন
Oh,
Similar matter.
No, no, in this matter,
মধুমিতা ব্যানার্জি
appearance or
মধুমিতা
behalf of-
ব্যানার্জি সিমিলার ম্যাটার
You did not appear when it was passed. This order was passed. Exchange. Have you served upon the commission?
ইয়েস ইয়েস সার্ভিস বোধহয় ইন রেকর্ড আছে স্টেট অলসো অ্যাপিয়ার্ড
Has to be again
Hmm.
18 তারিখ again adjourned. There is a group of similar matters. One affidavit would suffice. So you check up whether you have filed opposition in any either of them. He says that you have not done so.
let me check. Let me check.
So 18th November it comes, it again has to be adjourned, না? এই 18 তারিখ রেখে দাও তারপর।
এটাতে দিলেই সবারটা
Please tell us on 18th whether your affidavits are, you file one, I don't know whether you can, one affidavit will cover the issue.
it will cover
Very well.
it will cover madam one
Receipt most probably on his behalf.
বেশি অনেক মামলা হয়েছে।
দেখি কি হয়।
Yes.
So that receipt করেছে।
বেশি হয়ে গেল কি?
18th, let us come back on the 18th, because weekend is intervening. And
We have actually said that, Dr. Bhatt.
my lord.
Appeared on it.
No, actually, since I'm not holding the brief and I'm unprepared, I'm a little disoriented. What is it?
this was from your Rochester record
Yes.
He will help you. He will give a copy again if so required. Unless that affidavit comes, we cannot hear it finally.
Right, right.
Yes, next.
grateful to Lord.
Item number 8.
Your Lordship, I'm for the appellant. Your Lordship, I'm paying for a 1 week accommodation, Your Lordship. It has just come to my, we have served upon the other side, but it has just come to my notice that the
2
process
weeks.
has not been completed. So they will
Huh?
receive,
Service has not been completed.
yes, Your Lordship. It will take 2 to 3 days.
Then why didn't you mention, madam? When
Your,
you mentioned, you were aware that service not completed.
yes, Your Lordship, I mentioned it was admission appeal, Your Lordship, and we did it yesterday itself, but the consignment will take
2
2 to
weeks,
3
yes, next.
I'm appealing for secondary board, Your Lordship. My Lordship, Mr. Anjan Bhattacharya, advocating for, appearing for the appellant, he is in a court number 8, division bench,
Call him, call him,
short passover man.
call him, let him start. দেখি দাও। শুধু মুডটা ভালো থাকে। এটা আমরা শুনেছি।
Page 63, order of the president.
You are for the board.
Board, Lordship.
Yes. Yes, Mr. Bhattacharya.
But, may I come back on Monday? Or one appeal bail is going to be heard just now. Mr. Milan Mukherjee is appearing before Justice Orijit Banerjee's division bench. My matter is next to next. This will take some time. But if your lordship so permits, otherwise, I will press. Only this much. This is a case where I am questioning the decision of the board and the power of the board.
Next Friday, Guru.
Lordship, I'm grateful.
Yes.
This last week, the matter was 15 September, but today is unfortunately Mr. Kamalesh Bhattacharya, his better half is expired. And that's why I'm praying at the 2 weeks time because he's leading me, myself. Dr. Patro is there. The Lordship, this matter, his better half hasn't expired, and that's why Lordship, this I'm praying at the fortnight time.
2 weeks he will return. 2 weeks he will return.
Yes, yesterday I talked to his the clerk this, and he also said this.
3 weeks, Guru. 3 weeks.
Lordship, yes, I'm praying.
Yes, 3 weeks.
Okay.
I'm for the Appellant University. 11, I appear for the writ petitioner respondent. There was a direction to file an exception to the report filed by the state. It was scheduled to appear. We are out of time to file that. I am praying for a very short extension that your lordship kindly gives me. Very short. 1 week is enough.
25th November.
Lordship.
Exchange your affidavits in the
any day after 28th, any day after. It is difficult.
9th December.
Lordship.
And in this matter, Mr. Vishwarup Vishwas appearing for the respondent petitioner. Lord, I am paying not this week. My similar matter has been fixed, my lord. 18 physical education.
Nineteenth, Guru.
But item 12, Oh, 19. I am for the petition, in item 12. Appellant.
19th. He's seeking adjournment for this day.
কোথায় চলে গেলেন?
Yes. In this matter, I am for the writ petitioner. Last occasion, my senior brother, Dr. Patro, already concluded his submission, my lord. Only one point of involvement, kindly remember, two
My
non-joining.
brother heard it. My
Pardon?
brother heard the matter along with me, or
No, your
just
lordship and my
your-
lord Justice Ritabroto Kumar.
Then it has to be heard afresh.
My lord, today I have some difficulty. My brief has not come. If it is taken up on Monday.
সোমবার ডাকো।
Deeply obliged.
এই অম্লান দাও। নেক্সট ফ্রাইডে করে ডেকে যাও, তো মামলাগুলো ডেকে যাও, পরপর ডেকে যাও।
I led by Mr. Bhattacharya.
Yes.
50? 50? Oh,
15, anybody for the appellant?
No, no, brother. I am appearing for the UGC, University. 15.
15, my lord, I am for the writ petitioner respondent.
দেখো, পারছো? যেদিন পারো একজন করে।
15 chale. That includes an appellant name.
নেক্সট ফ্রাইডে
Next Friday. Next Friday. Next Friday. Well, because of the petition is much appellant is yes.
I mean, 16, I am for the university, my lord, led by Senior Counsel Mr. Bhattacharya.
Are you ready? Are you ready in the matter?
Yes, my lord. Mr. Bhattacharya is coming, my lord. I am also ready.
Yes, file দাও।
হ্যাঁ করেছি, এটকে সার্ভিসটা দে তো, সার্ভিস ডাক একটা সব।
What is this regularization?
Not regularization, not regularization.
Then
My lord, advertisement was given for the
you are for the,
I am for the appellant candidates, my lord.
then why he is saying Bhattacharya? Because Nilanjan Bhattacharya.
Nilanjan Bhattacharya.
Service
Yes.
to case to
This has come for final hearing.
final hearing. My lord, I am led
No
by
paper book.
my lord, I am paper book, my lord. Paper
Paper book is there.
my lord. Paper book is
There was
there.
a direction, my lord, to serve the state.
Yes, my lord, I serve the copy upon the
The
state.
state is a necessary partner.
Yes, state I serve
Who
the
is
copy.
the state, Mr. Bujotwada?
এটার জন্য কি আছে জানো?
Paper book কোথায়?
There is no paper book.
My lord, paper book. Last
I-
occasion also paper book, my lord.
Ache. Acha, who is for the state?
Just now, if you not remember, my lord, I served and I talked with him, my lord. I personally talked with, I served, my lord. Just now. যেটা বললে যে এখন যেটা এখানে নেই ওখানে ফোন কর না এটা তো লাস্ট ম্যাটার নাকি এরকম দুটো 10 সেকেন্ড দিতে হয় দিতে পারবো না এরকম দুটো
Who is for the state? State is the answering respondent.
my lord I served pursuant to the order of your lordship my lord I served the my lord last occasion your lordship directed me last occasion
Further, yes.
my lord I serve along with paper book my lord affidavit of service in my lord within 5 minutes my lord my lord affidavit of service my lord
That we
personally I handed my
You know who has been interested,
my lord
who has been engaged?
I forgot the my lord, I forgot the
Lordship,
name of the-
kindly give a 5-minute passover. My learned senior friend will bring the state advocate, my lord.
Mr. Chattopadhyay, you ascertain who is appearing and come back next Friday.
my lord today my lord lordship Mr.
How many we are
5 minutes not paying then my lord Friday my lord
no, we will start hearing. There is no problem. Since morning we are sitting, all matters either engaged in another court. There are nobody is interested to do the matter. Nobody is interested.
I am interested, but only my lord, 10 minutes, my lord, I am interested. My lord, I will place the case before your lordship, my lord. My lord,
All right, place the case. Take up the paper book.
পেপার বুক তুলে দিন।
একটু যান দেখবে
Yes, where is the impugned order? Whatever you. How many paper books you file, Mr.? Two volumes. And university has used a supplementary affidavit. You got it?
My lord.
এটা কি পেপার বুকে রেখে দেবো দোকানে?
না।
ও তাহলে সাপ্লিমেন্টারি এফিডেভিট পাস করে ওই
এই
সাপ্লিমেন্টারি এফিডেভিট দিয়েছে।
আরেকটা কপি আছে দেখো।
হ্যাঁ।
I also filed supplementary affidavit. হ্যাঁ এখানে দেখো কি আছে ডবল করে নিন advocate learned advocate DC Day. This is affidavit of the and service, my lord.
এই তোমার কাছে স্টেপলার আছে কি? ওইদিকে না ওইদিকে না অন্য দিকটা এই দিকটা
আছে
Yes, page
91. Simply order passed by the honorable single judge. অন্যতম ঠিক আছে ঠিক আছে এটা আপনার কি একটা রঞ্জন আছে কিন্তু স্টেটের প্রেজেন্স ছাড়া হবে কি? ওর অ্যাফিডেভিট তো দেখিয়ে দিয়েছে। পারবো না।
Then university is supporting you.
Yes,
So, we have to hear from the state.
that's true. On the last occasion also same situation, state was not there.
Service code.
Your state.
No, I'm for the university.
Then we may serve again because of waiting for some time. I time limit করে দেয়, কি করবে?
No, which advocating?
মানে as per the আরে জজ সাহেবকে তুই চিনিস তাকে? থাকলে নোটিস কর যে এসব বলতে চাইছে।
Because after hearing Mr. Bhattacharya, he will support the case of the petition. So it's a question.
Only predicament is the control of expenditure act. Because until and unless the state grants sanction, we are our hands are tied.
So they are appointed against permanent vacancy.
No, Malad. There are only 2 sanction posts, and that is the reason they were appointed in a temporary post, and Malad, their appointment letter also given for a temporary post.
বলেনি জজ সাহেবকে জিজ্ঞেস করছে বলেনি। Look now, law is well said that temporary post cannot continue for eternity.
Because previously, Malad, there was a
Appointment against post of permanently. Mr. Bihani বলেছে। ও আচ্ছা।
Advertisement.
Do you have the regulation? Regulation 31?
Yes, Malad.
জেরক্স গুলো দে ইয়ে দেখতে ভুলে গেল রেগুলেশনের জেরক্স My lord, can you take the trouble to turn to page 51, the letter of appointment? In fact, that indicates, though it is named as temporary, but the nature is permanent. Page 51. Your appointment will be on temporary basis, shall be on probation. Because there is no question of any probation on a temporary appointment. Ordinarily for a period of 1 year from the date of joining, then pay band. And retirement benefits will be admissible according to university rules and statutes. No question of the retirement benefit for temporary employees. Then, my lord, we will be pleased to turn to the next page. I'm just taking a lordship note as a glance. Clause 8, your services under the university will be governed by the Bardwan University Act, statute, ordinances, regulations, so and so as in force and as may be prescribed and amended from time to time.
Yes.
Then you shall have to obtain your release from your present employer, if any, in order to join this university positively within 1 month. And not we are all in employment somewhere else. This is the below the nature of employment. And they have been continuing since 2016. Now the Supreme Court.
Every year extension given.
All time. No.
Have extended them every year.
But in their affidavit, they have in fact admitted they support our cause. They say yes, this was the system which was followed by the government from time to time. But this time we are waiting for sanction. Now the Supreme Court has come out very clearly that you cannot allow someone to continue for eternity on the ground, alleged or temporary or casual.
And one day unfair labor practice.
That too by the state. That's why the earlier division bench will have wanted an affidavit from us whether the artificial break was there at all or not. We have filed an affidavit. So Supreme Court judge. Negotiate patrol. Team transfer.
But Mr. Bhattacharya understood, but it has to be against a sanctioned post.
Sanctioned. But if it is not a sanctioned post, how could they continue? That's more fundamental.
But Mr.
You are allowing us to continue for
all the
eternity.
judgments as well as unfair labor practice, Supreme Court has
No,
said
now the Supreme
whether the post is a sanctioned post.
Now the Supreme Court is immaterial. It's employer's duty. Jaguta already
sanction post.
Kindly come to paragraph 4 of the Supreme Court judgment. I am told me that it was handed over to your lordship.
No, Mr. Bhattacharya, very recently we have delivered a judgment on unfair labor practice, and but that case it was a sanctioned post. Have you? I don't know.
No, I have not gone through that judgment, but I think
no. Your argument is that is immaterial.
Immaterial.
If you have continued that effect, Mr. Bhattacharya, show us.
Yes, no, kindly takes up this latest judgment on Supreme Court.
Will you please give the citation?
Yes, 2024 is.
It is 2024 SCC.
SCC online, Supreme Court, page 3826.
विनोद कुमार
Yes, Mr. Bhattacharya, which paragraph are you placing?
Below the paragraph 4, below the nature of employment. The appellants before this court, paragraph 4.
Yes.
Were originally engaged by the Central Water Commission on part-time ad hoc terms. Applicant number 1 was appointed Safaiwala so and so. I am not troubling my life with the nature of duty, but the part-time and ad hoc terms. Then Lord, kindly come to me, Lord. Paragraph 16. The appellant's consistent performance over their long tenures further solidifies their claim for regularization. At no point during their engagement did the respondent raise any issue regarding their competence or performance. On the contrary, their services were extended repeatedly over the years. And their remuneration, though minimal, was incrementally increased. In our case, we have been always placed in the pay band, which is done for the regular employees. The respondent's belated plea of alleged unsatisfactory service is not applicable in our case. Then in this background, the Honorable Supreme Court says, after considering Uma Devi at paragraph 18, and paragraph 20, sorry. Paragraph 20. They kindly come to paragraph 22, after having considered Uma Devi in detail. The pervasive misuse of temporary employment contracts, as exemplified in this case, reflects a broader systematic issue that adversely affects workers' rights and job security. In the private sector, the rise of the gig economy has led to an increase in precarious employment arrangements, often characterized by lack of benefits, job security, and fair treatment. Such practices have been criticized for exploiting workers and undermining labor standards. Government institutions entrusted with upholding the principles of fairness and justice bear an even greater responsibility to avoid such exploitative employment practices. When public sector entities engage in misuse of temporary contracts, it not only mirrors the detrimental trends observed in the gig economy, but also sets a concerning precedent that can erode public trust in governmental operations. Then the ILO, probably which was also considered by your lordship in my lord's own judgment. Then paragraph 24, taking a judgment from the US court, I am not troubling my lord. Then paragraph 25, it is a disconcerting reality that temporary employees, particularly in government institutions, often face multifaceted forms of exploitation. While the foundational purpose of temporary contracts may have been to address short-term or seasonal needs, they have increasingly become a mechanism to evade long-term obligations owed to employees. These practices manifest in several ways. I am not also troubling my lord. Then paragraph 26. While the judgment in Uma Devi sought to curtail the practice of backdoor entries and ensure appointments adhere to the constitutional principles, it is regrettable that these principles are often misinterpreted or misapplied to deny legitimate claims of long-serving employees. This judgment aimed to distinguish between illegal and irregular appointments. It categorically held that employees in irregular appointments who were engaged in duly sanctioned posts had served continuously for more than 10 years.
Yes, duly sanctioned post.
That is Uma Devi. Now this court is explaining. 10 years should be considered for regularization as a one-time measure. However, the laudable intent of the judgment is being subverted when institutions rely on its dicta to indiscriminately reject the claims of employees, even in cases where their appointments are not illegal, but merely lack adherence to the procedural formalities. Government departments often cite the judgment in Uma Devi to argue that no vested right to regularization exists for temporary employees, overlooking the judgment's explicit acknowledgement of cases where regularization is appropriate. The selective application distorts the judgment's spirit and purpose effectively, so and so. In light of these considerations, in our opinion, it is imperative for government departments to lead by example in providing fair and stable employment. Engaging workers on a temporary basis for extended periods. Now, this is most important consideration, especially when their roles are integral to the organization's functioning. Not only contravenes international labor standard, but also exposes the organization to legal challenges and undermines employees' morale. By ensuring fair employment practices, government institutions can reduce the burden of unnecessary litigation, promote so and so. In view of the discussion above, the termination was set aside and they were directed to be taken back in.
They were appointed upon advertisement. They participated in a
yes, regular process. Kindly come to page 55. It's a regular process of recruitment. Page 49. So this was advertisement number 5, dated April 7, 2015. The applications are invited from Indian citizens for filling up the following post of temporary basis in prescribed form to be downloaded. But it does not say that this is not sanctioned post. The following post means the posts are there. Otherwise, they couldn't have mentioned this post. On temporary basis in prescribed form to be downloaded from the university website. Completed application in prescribed form. But this is the requirement. I am not troubling my lord. The posts are mentioned. Technical assistant grade 2. Pay band is mentioned. qualifications are given. On the basis thereof, my lord, we had applied, a selection process was undergone, and appointment letters issued at page 51.
This appointment was in 2016.
16.
How long did you work? Mr.
Continue, even today.
Then what did you challenge?
I said that I should be,
No, why did you come and file the writ petition? Challenge?
because my lord, they were taking under course of 1 day break and keeping us continuous temporary.
No, they adopted a resolution which you have challenged. Can you show?
Lord, my prayer is kindly come to me, Lord.
30th January
That-
2017
yes.
resolution.
That is the resolution I just placed before Lordship.
Page 78.
Page 78.
After this also you were extended after 17.
We are still working with the highly qualified persons. The same thing I had to face, my lord, in a matter before the here the university, my lord, sometimes my lord, brings, my lord, laterally people for enrichment of the academic atmosphere. Hmm. And these people will have very regular employment.
Basic pay.
And 78, my lord, find that the question of sanction posed the
That's very good. Then how did you continue them thereafter?
my lord, they are continuing, we are paying them, but as a temporary, my lord. Because our difficulty is that
No, this amount which you are paying against a regular pay scale, you must be availing fund from the government.
for the my lord, for temporary
The reply to-
appointment, my lord, we did not, my lord.
Then who pays? You pay.
University pay, my lord.
University pays. How will you establish that? Because all universities are released grant. Then then utilization certificate is issued by you.
Because Lordship, at page 78,
No, your only defense was Regulation 31.
Regulation 31 is
Yeah,
only
after-
meant for my lord, the permanent employee.
No, that's not right.
Regulation 31, that is for permanent employee.
Acha, you will get. Let Mr. Bhattacharya finish.
Now, my lord, therefore, this I had challenged. Now, my lord,
Page 79.
79 is
79.
notification, that is which is under challenge.
Minutes.
1 day break.
Hmm.
Writ petition, what did they say? Joined on Ato and it was resolved. Services be extended for 1 year.
This 1 day artificial break letter already been declared by our courts, my lord, are illegal.
Now this is 21st September 2017. Where is 30th January 2017? 30th January.
Resolution dated 30th January 2017. Page 76. 75 rather, right? Minutes of the 7th meeting of Executive Council.
Where is the relevant portion, Mr. Bhatt?
The next page, item number 226.
Yes.
The council considered the matter of reviewing performance of the technical assistant grade 2 who have been appointed technical assistant grade 2 and joined on such and such. It was resolved that the services be extended for 1 year, keeping 1 day break.
So challenging these two, you approach the writ court.
That this 1 day break you cannot undertake. This is all artificial break to show that we are not continuing. We are not permanent.
No, you were engaged on 14 January 2016.
Yes.
After 1 year, 9 months. So 14 January, you did 1 year. Then they adopted a resolution on
1 month, 9 months, 1 year, 9 months. After that, you will be extended, but 1 day break.
no 2017, 30th January, they adopted that resolution.
Yes.
So that is less than 1 year because you
No,
were
well, it's more than 1 year. I was appointed in
just 14 January 2016. Oh, Oh, you challenged the very first decision.
Very
of
first
the-
decision of 1 day break that you cannot undertake this.
It will come and say that it is not a sanctioned post and you have not taken any prior part. Now you show that it is against sanctioned post or not.
But page 78. Because after their appointment, it was found that
I'm putting it to you.
a notification be issued by the register in pursuance to the council resolution 30th January 2017 under item number such and such that their service be extended for 1 year keeping 1 day break.
Yes.
Annual increment that has been given to the technical assistant group to be withdrawn, recovered from their salary in the next month. A detailed report be submitted by the register BU for appointment of 18 technical assistant grade 2 against the vacancy of only 2 posts.
Point number 3.
And in my supplementary affidavit, Malad, that what I have submitted on the last day, in 2020, the last document, Malad, in my supplementary affidavit, Malad, the technical assistant agent.
पेज बोलिए 26
Page 26 of my supplementary affidavit, I have said that there are technical assistant grade 2, level 8, number of post 4. That is Malad, the government of West Bengal Department of Higher Education document. Malad. Page 26 of my supplementary affidavit, at the bottom, Lordship find technical assistant grade 2.
Technical assistant grade 2. Level 8, number of post is 4. Whether you appointed against this post.
No, this is a 2020 notification.
Then where is the notification prior to advertisement?
Prior
When
to
you
advertisement, Malad, prior to advertisement, there are Malad,
Now, is there any?
in my supplementary affidavit, I have said, Malad, since 1976, these posts were created by the University Grant Commission from different program wise, Malad. The different program wise, these posts were created, and Malad, the appointments were given.
This is not creation, this is rationalization. What you are showing, page 26. 2020, creation was the subject. Now, I'm Director Governor is pleased to create marginally noted 49 posts under different 7, 9 in the university in the rational entry pay, rationalized entry pay. So, when you went, your advertisement says that I am calling for
Page
your first line of advertisement says that are filling up the following post.
Yes. On temporary.
That is the on temporary basis, all right. But this following post, how did you make budget allocation for this post? If the government has not sanctioned the post, now, Mr. Bhattacharya, you kindly come to their pay slip.
pay slip
Pay slip kindly see. You are giving provident fund, you are getting house rent.
71.
Page 71.
Everything, Malad.
Everything you are
Deducted amount towards provident fund. You have given great pay, DA, medical allowance.
He was fixed in a pay band, fast employment. Because temporary cannot be on pay band.
Even the house accommodation also.
Yes, house rent also.
Now, then you, Mr. Bhattacharya, you must be having some document in your custody prior to going for advertisement.
Yes, that documents I have annexed in my supplementary affidavit.
No, that is 2020.
No. From 76 onwards, Malad, all the documents regarding technical assistant I have annexed.
These you did not annex in your opposition before the writ court?
In the I fairly submit in the opposition, the previously the stand of the university is that there is a no sanction post. Their appointment was given without any sanction. And secondly,
So you give us a chart that since 76, so many posts were approved. This is the letter, and that has been appointed on provisional basis.
I tell your lordship, 76, on different program of UGC, these posts were created. Subsequently, state government approved this technical.
Which posts were created?
Technical assistant post.
Technical assistant, how many posts were created? You give us a simple list.
Now, just a minute, my lord. Now there are difficulties, my lord, on 2010. Previously, there was a writ petition filed by some of the technical assistant asking for their teaching status as a teacher. Now, that matter was disposed of by this honorable court, directing the university to grant them as a
teaching status.
Teaching status.
Though they were initially in unsanctioned post.
Unsanctioned post. Now, my lord, what happened? After that, the university wrote to the state government. State government approved, but with a rider. That is, I have annexed this letter also. That is at page 24. হ্যাঁ স্যার 13 তো এটি এখন আটকে আছে তো এর জন্যই তো পরবর্তীকালে স্যাংশনের প্রয়োজনটা হয়ে যাচ্ছে
Yes, 2014.
14 February 2013 second paragraph the post of teacher, senior teacher, selection grade teacher, as the case may be, conferred upon them are personal to the petitioners in dying cadre as a special case exclusively to the petitioner without citing any sort of precedent in any circumstances. So this is now, my lord, after that, normal, but
there had been no engagement of teacher.
Yes.
But who preferred that writ petition? This
at their this technical, these are technical assistants. They who were writ petition asking their statement.
That was allowed by the court.
Allowed by
now the government accepted it, saying that it will be a dying cadre. Means those posts will not be continuing thereafter, after they retire.
So, after
as a consequence of this, how many technical assistant posts became vacant?
From this page document, at page 76, I find that there are only 2 vacancies.
No, that is creation.
That is creation,
After technical assistant went to High Court, saying that you give me teaching cadre. High Court allowed. So to comply with the High Court order, state government granted you permission to change the status, and those posts which were created in terms of court's order maybe,
yes,
those posts were for the teachers from the post of technical assistant.
Oh, yes.
So then the post from which they have come, how many posts were there?
That is page 76. I find that there are only 2 posts, but the recruitments were made in respect of 20 posts. Subject to let me check.
24 teachers were appointed. How many teachers status change was of how many teachers? 27 to technical post. Uh, 2015 advertisement. Now, this document at page 26, which you showed us, this document is of 2013. So when you publish the advertisement, there must have been some resolution of the Executive Council saying that though we do not have a sanction post, Because then Mr. Bhattacharya will argue that at best it can be an irregular appointment, not an illegal one. Then Uma Devi goes. Now, sanction post, you assist us that prior to publication of the advertisement, did your executive council in any resolution note that though we are not having a sanction post, our exigency requires induction of technical assistance because they have been sent to the post of teachers in terms of court order.
That resolution, certainly I will submit before your lordship. But what I find from page 78 that these 18 appointments were made. Page 78.
That is
wherein the report called for by the then Vice Chancellor from the register for appointment of 18 technical assistant grade 2 against the vacancy of only 2 posts.
This is exactly what we are wanting.
Yes. So the relevant executive council resolution that I will submit before your lordship before their advertisement. Now, after this 2013 notification from the government that this is a cannot be a precedent, that this is the dying cadre post, if your lordship kindly consider the section 3 of the Control of Expenditure Act.
Dying cadre while they were converted as teacher.
Their cadre will be dying.
This conversion specific to them.
Now, my lord, our hands are tied only because of section 3 of the
So
code.
when your hands were tied, why did you go on utilizing their services? This is absolutely unfair labor practice. Now you are shifting the burden onto the state. And you don't have the power to disburse pensionary benefits also because all funds are sent from the government.
Yes.
So you have created an avenue for them to come and challenge this. This is in fact like municipal appointments. First you enter, then go to High Court. You take all municipality matters. We have delivered a judgment, 30 years of service utilized, regular pay scale given, revision of ROPA given. Now when the retirement came, said no, how can we give pension? It is not a sanctioned post. Is the government a model employer cannot do now? Or you distinguish this Jaggo
Paragraph 18.
Paragraph?
Paragraph 18 of this judgment. The issue is not only, my lord,
it is.
Here, some of the
The rule are integral to the function because of the fact years after years they are utilizing their service.
Paragraph 8.
Paragraph 18. Here, my lord, the issue is some of the employees, they were given permanent appointment or regularized their service. Standing on the same footing. And the court find that this is in violation of Article 14. Thereafter, my lord, the court discussed, my lord, the applicable.
What did we didn't for?
My lord, paragraph 18, my lord. The appellant have also established that individuals with lesser tenure or comparable roles were regularized by the respondents. The counsel for the appellant had submitted a seniority list for the employees working as multitasking staff published by the respondent department on such and such, wherein the following employees were part of the staff without required educational qualification. Then, my lord, a bare perusal of the aforementioned list shows the preferential treatment accorded to those individuals despite their shorter service duration and no educational qualification. This exemplifies the discriminatory behavior and lack of uniformity in the respondent department approach. Such disparity violates the principle of equality enshrined in Article 14 and 16 of the Constitution of India and they cannot sustain in law. So there, my lord, the basic allegation that some of the employees standing on the same footing, they got regularization, but the petitioners, there is a discrimination on the some of the employees who are working on ad hoc basis.
So we shall finally see paragraph 17. How do you wriggle out of these regards? Fourth line, engaging workers on a temporary basis for extended periods, especially when their roles are integral to the organization's functioning, not only contravenes international law, but also exposes the organization to legal challenge.
Yes. But my lord, in our case, my lord, though we are, my lord, we are the playing the role of employer, but subject to the sanction of the state government for their permanent appointment. As my lord, we are, my lord, the section 3 of the Control of Expenditure Act is there. If your lordship kindly consider.
Control of Expenditure Act Control of Expenditure
with the substantive nature of their roles and their continuous service akin to permanent employees.
এসে করে দিলে আমাদের কোনো আপত্তি নেই। স্টেট এসে বলছে করে দেয়, আমাদের কি আছে, আমাদের তোদের দরকার। এই বলো যে আমাদের স্টেট দিক আমরা অর্ডার করি না। ইউনিভার্সিটির উপর ডিরেকশন দেবে, স্টেট গভর্নমেন্ট পারমিশন দেবে না, সেখান থেকে ইউনিভার্সিটি কন্ট্যাক্ট হবে, এটা হচ্ছে আমাদের।
Advertisement, how many sanction posts were there in respective categories?
Lots.
Technical assistant.
Yes. I'll bring the melody.
Yes, and how many posts was filled up and how many posts are vacant?
And the relevant, if any, executive council resolution regarding this.
And any communication in between state and you regarding that appointment?
So far
If
as
you have.
communication is concerned, I think there is no such communication before that. Because if there be any communication, that only recruitment would be in respect of this 2, not for 18.
State will come and will say that it was not
because
permanent,
the stand of the
post, sanction post, And hence university was required to take prior permission from the state.
Because the university need their support, their and for the smooth running of the university, their support is necessary. But our hands are tight since the approval of the state is there, and we ought to have take the approval prior to their appointment.
Where do you have regulation 31?
Yes, but I was willing to place that.
Already handed over. Xerox copy.
Before your lordship reads 31, kindly come to the definition of employee. That is 1(6). What does the employee means? Employee, I got it.
Yes.
Employee in relation to the university means any person employed by the university. But you are employed by the university, and now kindly come to 31.
Page
39.
Page 39.
Got it?
Yes.
Every teacher, every officer, and every employee, this is very important, of the university shall on appointment as such be provided with a letter of appointment containing such terms and conditions of appointment as may be prescribed by the ordinances. And Lord, you are appointed, Lord, on probation. They say temporary, but on probation for 1 year. And then subsection 4 of 31, but sub-regulation 4. On satisfactory completion of the period of probation, a teacher or an officer or an employee, as the case may be, shall be confirmed with effect from the date of his appointment on probation by an order in writing made by the court in this behalf, and the fact of such confirmation shall be communicated to the persons concerned. Proviso. Provided that if on completion of the period of probation no such order of confirmation is made and communicated to the person concerned within a period of 2 months of the completion of the period of probation, the person concerned shall be deemed to have been confirmed with effect from the date of his appointment on probation. But why should I not get the benefit of this provision? Because I do come under the definition of employee. My appointment, kindly come to my appointment at page
51.
page 51.
Has been appointed
It's a letter of appointment issued by the registrar of the university.
18/1/2016 and 19/1/2016. 18/1/2016.
There, the appointment says your appointment will be on temporary basis and shall be on probation ordinarily for a period of 1 year. Lord, I have never heard, I am sure my Lord also did not have had the opportunity come that
There cannot be any probation in temporary.
the nature and the putting them in the pay band.
How do you, what is your reply to this stand as regards the control of expenditure?
That is applicable. That's the university's business, not my duty.
But that says that university cannot fill up a post without the previous sanction.
But with this continuation, it appears that every time the audit is made, the government is well aware. The government cannot say that we didn't know. Every year, the audit is made of the university accounts by the government auditing department.
Executive Council of the government.
Therefore, this is really,
There is a government nominee in Executive Council.
yes, has to be. Therefore, the government had the knowledge, by conduct, the government has approved this. Therefore, that would be a technical compliance. Well, as a matter of fact and nature of duties, nature of employment, I was asked to leave my other job. Clause 9 says you'll have to obtain your release from present employer. It is a temporary appointment, but they will never ask me that you will get released from your present employer. And we are governed by the university statute and rules. Now, my lord, this formal sanction which the university is suffering, university still feels that our job is necessary. It doesn't say that you are not required, you go out. But when question of money comes, they are feeling now handicapped because of the lack of formal compliance, and that would also be issue a mandate in the facts of this case.
No, this, Mr. Bhattacharya, this section 3 of the control of expenditure says that notwithstanding anything.
Yes, yes.
Shall after commencement of year appoint any person to any post without the prior sanction of the government.
Now, that is the requirement of law. But the requirement law has to be also be followed by the conduct of the parties. But this is not an individual. I say, my lord, the government department's conduct. My lord, here the executive council of the university, in fact, after the new law, the nominee of the department is much higher in number than, my lord, other council members. University nominee, government nominee, VC's nominee, UGC's nominee. All these officers were there to see that there is no infraction of the rules. When they have not allowed this, they have deemed to be have taken sanction. This deeming sanction, Milord, in Mahamud Sabish will have to Milord take records too. Now, my lord, another thing, my lord, if your lordship takes the trouble, there is a situation. Now, this says the vice chancellor under the ordinance 10. I'm just reading out. In case of situation of emergent nature, the vice chancellor may make ad hoc appointment on temporary basis for a period not exceeding 6 months. That
this is where.
But this is ordinance. Therefore, if it was a temporary, because that provision also there that I need a temporary person. But this is not temporary when you go through the entire selection process.
Yes, 71.
But ordinance 10, ordinance 10 kindly come to subclause D. In case of situation of emergent nature, vice chancellor may make ad hoc appointment on temporary basis for a period not exceeding 6 months. Had it been temporary, it couldn't have continued beyond 6 months. And send a report to the executive council at the earliest. Any extension beyond 6 months shall require the prior approval of the executive council. But such employee as appointed on ad hoc basis shall have no claim for automatic absorption. But we are not within this parameter. Our appointment was a regular selection procedures, putting in pay band.
Temporary.
of the ordinances. Chapter 2,
Page 72.
page 72. The chapter 2, ordinance 2. Here, my lord will find substantive pay.
Yes.
The Roman 12.
Hmm.
I've got it. Substantive pay means the pay of the permanent post, which a non-teaching staff holds substantively, but does not include special pay, personal pay, or so and so. But when you are placed in a pay band, the substantive pay. And then again, the definition of temporary post and probation. Next page. Chapter 2. Roman 20, temporary post means a post declared as such, carrying a definite time scale of pay and sanctioned for a limited period of time. Kindly will underline time scale of pay, but not when it pay band, which is regular substantive pay. And what is probation? Probation means employment on trial basis in or against a substantive vacancy in the cadre or post of a department for determining the fitness of a non-teaching staff for eventual substantive appointment. Everything was done according to law. Now, Mullah, at the fag end of our career, after having Mullah continued 17 years, they say the Expenditure Control and Expenditure Act will stand in the way. It cannot be done. That will be a highly Mullah arbitrary. And I am told Mullah, the university has Mullah, shown us as permanent employee in their website. That is in the supplement affidavit filed by my client. Mullah.
You have filed supplement?
No, they have filed.
They have also filed one. I have.
The order of foreign bill.
They are actually supplement.
For ornamental.
Mullah, the other division bench wanted us to file this affidavit. That's why we have filed it. Let kindly turn to page 80. This is the Burdwan University employees master. Arnab Kumar is one of the petitioner. And page 81, he is shown as present designation, technical assistant grade 2, nature of employment permanent. And similarly for other Milord petitioners.
This was heard by Justice Sen.
No, it was heard by Milord Justice Tandon. আগে কে শুনেছিল? But I am told it was initially heard by the Honorable Justice I.P. Mukherjee, then by Justice Horish Tandon's division bench.
Inter order seat আমাদের কাছে আছে। Order seat গুলো দিয়ে। এই যে
এটা গোটা এমসি এমনি জিজ্ঞাসা করছেন ওটা ওর সঙ্গে মামলার কোনো সম্পর্ক নেই। And but here I have annexed the status of all the employees. I have just shown one. That's all.
Yes, Mr.
Look, I have just shown one, but I have annexed all the employees. All of them are shown as permanent.
They are working till date.
Till date.
না পাঁচজন ছেড়ে চলে গেছে।
So those who have left the job, I am not concerned.
Then how many have left job?
Not, that I have also discussed in the supplementary affidavit.
So then you are not pressing the.
No, for them it's not necessary. Because they have already, paragraph 6, I have named Ajoy Mondol, Suraya Khatun, Shilpi Shaw. They've got a better job, they have left it. Paragraph 6.
All right, Mr. Bhattacharya, learned senior advocate appearing
My lord, I appear for the West Bengal Madrasa Service Commission.
What is item number 18?
70.
Same.
This matter was effectively hard, but now Lordship has to hear it.
Paper book আছে কোনো?
No, there was no direction for paper.
On the stay application. But the writ petition came to be dismissed on the ground that it was filed after expiry of the panel for appointment of assistant teachers in madrasas. Now,
Year selection.
this pertains to the notification of 2014 and process commenced in 2018.
Moment of written argument নিয়ে নিয়েছে। আচ্ছা, করে যেতে বলতে। তুই written argument নিয়ে নিচ্ছিস, দেখে ওটা মেরে দিতে হবে, আমি পড়াশোনা করছি। Then are you taking us to the order in place? That is which page, Mr.
Page 117 of the stay application.
এই যে মার্কিং করে রেখেছি।
116 rather.
অনেক বড় না? ও তুমি হচ্ছে আমি দেখে নেবো হোয়াটসঅ্যাপ, তুমি ওই ইয়েতে ব্রিফটার নিচে একটু
the panel, factually.
So why didn't you tell it to the single judge?
It was
Not on this.
there. Please come to page 96.
You are aware, Mr. Dhar, this about this prior preference of the writ petition?
No, there was no writ petition filed on the point, which was the issue, that is whether, what is the meaning of preference?
No, I'm
This
not
is
on the point. No, I was
No,
said that the
it
first
has
writ
been,
petition was filed.
That point has not been decided, Mr. Dhar. Only limitation it has gone.
Because of the reason, ultimately Lordship has to come to that part. Let my learned friend Melody.
No, we'll send back on remand. You are not insisting on the delay ground, we'll send back.
Effectively, once Lordship starts hearing, the real point in this matter will be while there is a division bench order saying what is the meaning of preference, whether single bench having passed an order, was it a judgment in rem or judgment in personam? There was an existing division bench order of our code, meaning what is the meaning of preference?
But that was not decided by the single judge. Single judge did not entertain. 5
Yes.
years delay, I will not accept.
Yes.
Now he says that he has filed previously a writ petition.
In
Yes.
You are not aware at this.
2018, inter alia by the appellant before your lordship.
Did you state that in your writ
Yes, that's
petition?
part of the
Writ petition?
part of the writ petition.
Writ petition was dismissed at the.
Writ petition part ছিল তো. This was disclosed in the writ petition. Oh, I'm sorry. This was by a supplementary affidavit. It was disclosed.
That is here, Mr. Owens.
This is at page 96.
Appearing on behalf of the intervenant.
Eh?
Intervenant party.
Party?
Same footing, my lord.
But the question was not whether.
To intervene.
But there are large number of matters are there.
The question was whether
may I just-
preference should be given to the trained candidates. That's on the one hand.
Yes.
There's the proviso to rule 3 of the subject rules. There is another provision in the same rules which says that the commission can fix cutoff marks for the purpose of selection. Now, the interplay of these two provisions was probably came to be tested before the Honorable Supreme Court when commission filed an SLP, which got dismissed from the division bench order. The main contention of commission was, by reason of this preferential treatment, there can be no compromise on merit, since the rules prescribe for a cutoff mark to be fixed by the commission for the purpose of selection of candidates. Now, the Honorable Division Bench has considered this and meant that if the rules itself prescribe for a preferential treatment to be given, then the interplay of these two rules
Cutoff will not subsist.
Will not, yes. I am grateful to your lordships.
My lord, in fact, this will be the real point. This is the angle that my learned friend is saying.
No, what are his applications?
I have the same
But-
footing, my lord. I am also deprived from.
So you have to go and tell the rich court why you have come to us.
In that at the time of hearing, means in the division bench, my lord, matter is pending. So that's why.
The lordship may decide once for all, because may I just say
Why
nothing,
you are giving us trouble, Mr. Dhar?
because of the reason that lordships may act second that because
Qualified.
no, that's okay. I'm not against you.
Loss of a forearm.
Because of the reason.
Suppose we defeat you, you will.
No, I understand. No, my reason is this. Lordships may not be required to actually see any of the documents much. It is a pure point of law. And point of law is this.
We understand, Mr. Dhar, but the point of law has not been decided by his lordship. His lordship said 5 years after expiry of panel you have come. As such, I am not entertaining.
Yes.
And if this fact is true that he has filed an application, writ petition prior there to subject to what you say, then we will set aside that portion and send it back on remand.
Madam, this is quite a fair, I would say. May I just take a note?
You are never unfair.
No,
Mr.
lordships are always fair, my lord. That I'm not saying just for saying.
A patient always chooses a better
No.
doctor for his treatment.
My lord, from this part, I think there would be
of mind that we
no, from this side, there would be absolutely no divergence when I say that, my lord, Lordship's kindness and that fairness, I need not say anything. May I?
Majumdar, give the copy of the
Entire writ petition, including, may I?
And
part of the can annex and page 108
না না আগে রিটের কপিটা চাই আগে রিটের কপিটা চাইছি ও
May I say this?
কোট করা আছে
May I take a call on this? Because if I find that it can go back, there may not be any requirement to waste any time of your lordships. And I will try to give my.
Yes, if you are thinking what the manner.
But if I find that no, what they are saying it's not correct, then only there would be requirement to.
Mr. Majumdar, show us that paragraph now in the writ petition where you have said it. Supplementary affidavit, page 67.
Please have a look at page 96 first. Not I just give the name of the petitioner in the cause title.
How many petitioners are here?
Not in the one. Not in the first round, not when I say that my client had approached, please come to page 71. That's the cause title.
Well, approach will not do. What we'll do is approach seeking that if two person gets similar marks.
You check up, Mr.
I would.
You check up?
Yes.
Please come to page 71.
This is a group writ petition. Many persons will.
But my client was there. But I'll just show you, Lordship. Page 71.
Yes, we have.
The 2018 writ petition. Please come to page 96, serial number 133.
The panel expired on
30th of June 2019.
It was 21st June 2019 panel expired.
21st June?
Yes. Because the panel was published on 22nd June 18. So after 1 year, under the rule, it expired.
Here it is court went on 30th June. Anyway, page 96.
My lord.
Page 96. Your name.
Yes. Now please come to the prayers in that writ petition at page 108 as quoted.
This was not before the learned single judge. It was there.
But it was not considered.
তাহলে কে অনিন্দ বোস
মাঝে মধ্যেই ভুলে যায়
108.
These were the prayers in the first round of litigation. Ground was of course different. Ground of challenge was different.
Yes, there. If so many persons coming together on X ground, then probably this is not a continuation of case of Y ground.
No.
That's what I'm saying. Y is the real issue.
To fill up.
Two persons having said.
You won't be suffering in any manner. They would have to come to 2 rounds.
Well, their suffering would be this, may I just say, not only me.
We will not pass any observation as regards the merit of the petition.
No, may I say what's the suffering? Because since
if you argue that point, then we have to.
No, I understand. May I say what's the suffering? Suffering is not as because I am appearing here as a commission. The order of the original learned single bench, which was by the Honorable Justice Gangopadhyay, which effectively they want to be implemented, was no matter what is the written marks, if he has this qualification, he should be appointed, and whoever are already appointed, they have to go. So therefore, there is an affectation also. It's like if they, because today it's all are filled up. So for about 7 persons, there was a directions. You have to accommodate, and for that reason, if you have to terminate the service of others, you have to do that also. That was done in a circumstances when the division bench of our court in a matter highly argued. In fact, I myself appeared where not Justice Gangopadhyay, then Mr. Gangopadhyay as an advocate appeared on identical point, that saying diametrically opposite thing. diametrically opposite thing, saying that preference would be two persons getting similar marks, then the person who has the qualification, he should be preferred. For an example, someone is getting 60, someone is getting 59.
This
To
point
get the prefer
subject to what my learned friend would say, submit. This point was agitated before the Honorable Supreme Court by the Commission when it went up in appeal from the order of the division bench.
Now, in
That was
matter,
personal.
the matter was relegated for consideration, which you showed.
Yes.
After that, an order
Rejected.
was. Oh,
Now, not in the second
now
round.
that
In the second round, we come up. This rejection came after expiry of the panel. Now, not before.
oh, this rejection was after expiry of the panel. Then challenging that rejection, you
In
came
the meantime, the
second
division.
round.
No.
In the meantime, the division
They did
bench
not
had
challenge that.
that no, you cannot treat them equal.
Division bench
In
against
another
that-
matter.
Oh, that's right.
In another matter held that this preferential treatment must be extended to all the trained candidates.
And the commission's decision was that this cannot be done. Merit could be
Retrospectively.
compromised.
Retrospectively.
Merit
Because
cannot
for
be compromised.
Then in a separate litigation, the division Supreme Court said what?
This division bench order was challenged before the Honorable Supreme Court by Commission. SLP got dismissed.
That means that you have to give preference.
Yes.
So that you ventilated through this
To
present
the-
petition.
Before
So when did Supreme Court decide? the
Supreme
issue?
Court decided in 2024, 16 December 2024, page 114.
Ashok, the present appeal has been preferred, challenging an order dated 19th
They appear for the appellate.
Okay. You are for the appellant.
My lord.
Industrial dispute. What is the matter? Regularization.
Lockout.
Which are
But in
others?
fact, there has been no
Who is it?
adjudication on all the issues referred to the tribunal
Who
for
is
appeal.
opposing you, Mr.
Yes.
Led by Mr. Dibyendu Chatterjee, my lord. He is on his legs, my lord.
Dibyendu Chatterjee.
Because
He's engaged
ultimately
before another court.
I understand ultimately Mr. Vikas Ranjan Bhattacharya.
He's engaged before another court, my lord.
Then we keep it in the monthly list, Mr. Next monthly list.
My lord.
আসছে? Yes. Who is your senior? Nilanjan Bhattacharya?
Dibyendu Chatterjee, my lord.
Dibyendu Chatterjee.
Mr. Vikas Ranjan Bhattacharya has to be.
Also,
appear করুন। Yes, next. পরায়ণ সরকার।
But I am appearing on behalf of Kolkata Municipal Corporation.
false.
একটা তো দেখছি 1997
Is it পলায়ন or it is পরায়ণ? Yes, Mr. Betal
পরায়ণ সরকার
or পলায়ন?
What is the meaning?
পরায়ণ
Then your matter.
Give me a short answer.
Huh?
পরায়ণ
Will you take adjournment to know the meaning?
Why assigned to us? Please, woman, since one of us is not inclined to speak up matter of personal, কেন? Personal কেন?
can be from
Correction of date of birth.
my lord, the fact is, my lord, two certificates are there.
আচ্ছা, let us go through the order.
দেখিনি আরেকবার রিপোর্টে তাই তো সেটাই করেছি কিছু
রামকৃষ্ণ মিশনের তো নম্বরই হবে না, এটাই কারেক্ট। আর কোনো বেসিসে বাচ্চা
পেজ কত
আগেরটা হলো পেজ 70, ফার্স্টটা এটা 97 দেখুন, ডেট অফ বার্থ 96 দেখাচ্ছে। আস্তে আস্তে বসুন, একটু বসুন, আপনি শুরু করুন।
স্কুলের হয়ে আছে
You are St. Lawrence. Yes, Mr. Betal. ভালো মামলা নিয়ে আসবে কি করে? ও কস্ট দিয়েছে 20,000 টাকা, সেটার জন্য এসছো? You comfort that.
There may be fault of the father, my lord,
Pardon?
while admitting, my lord,
Hmm.
the birth certificate has been produced by the father to the, my lord, school authority. There are two birth certificates. My lord, the municipality can, corporation can, my lord, say which is the genuine, and whatever the genuine is, my lord, that has to be followed, my lord. My lord, two birth certificates are page 70 and 96. Attending, my lord, after noticing, my lord, I come up before this office.
You were not there in the writ petition.
Yes.
তাহলে
Before 97. There's 70 and another
96. 70 is the original and 90, my lord, submitted to the school authority.
Kindly see page 38, the discharge certificate. The discharge certificate from Ramkrishna Sharoda Mission, Matri Bhavan. Here, the date of birth is 1/5/1996.
Sure.
At that
Yes.
bottom, thereafter, Your Lordship, page 70, registered with Kolkata Municipal Corporation birth certificate, and basis of this, here it shows 96.
Had a male,
96.
96.
Then, Your Lordship, very interestingly, Your Lordship, kindly come to page
90. What is page 96?
96.
Page 96 is the
Another
birth cert. No, my lord, there is a chronology. First page 38, Your Lordship, kindly come.
আচ্ছা ওকে বলতে দাও না
আচ্ছা ঠিক আছে
বলুন
My lord, I would rely on page 38.
And
discharge
we
certificate.
may also enhance the cost. You are dragging the parties up to appellate stage.
I rely, my lord, judgment of the honorable single bench, my lord, on this.
Yes, tell us what is the matter.
Page 38, my lord, is the discharge certificate. My lord, date of birth is, my lord, 1st of May 1996. And page 70 is the birth certificate, which shows, my lord, date of birth is 1st of May 1996. It has been issued on 31st January 1997.
1st of May 96.
It has been issued on 31st January
So
1996.
page 38 tallies with page 7.
7.
Yes.
Then
Page 7. And what about 96 is another birth certificate. It is, well, birth certificate of a year after, well, 1st May 1997.
no, this was issued on 5th of 2002.
Well, kindly see first birth certificate discharge Ramkrishna Mission.
আসবো, we will listen to you.
একজন দুদিন পর 2 বছর জন্য গেছে
সেটাই তো বলছি।
হ্যাঁ
এতদিন পরে ঘুম ভেঙেছে।
এতদিন পরে তা না
Here it is 1597.
97.
So
This one is, my lord, correct as per the act, my lord.
place of birth.
Please take your seat, no? We are
The person cannot have two birth certificates. My lord, by page 96, I was admitted in this school. When my lord, at the time of renewal of, my lord, passport, when I found after searching those documents, I detected this was the mistake. My lord will find in passport.
So what did you do thereafter?
I approached the school for correction. They denied. That is why, my lord, I approached before this honorable court. And the certificate of.
Then where is that denial? Where is that? When did you approach the school? In 2003.
Yes.
96 a bond. 2000.
Date of admission, date of discharge. His mother name is
Now, stay application page 51.
51.
No,
Yes, Madam. Page 50.
page 50.
It starts at 50, the relevant portion.
So you approached the school in the year 2002.
21.
21.
21.
20.
That is after 19 years. You got admission in the school in 2002.
97 ধরে সব হয়ে গেছে
97
পরে এইটা ধরে সব বয়স হয়ে গেছে মাধ্যমিক হয়ে গেছে ইয়ে হয়ে গেছে সব হয়ে গেছে এখনো এইটা দেখিয়ে চাইছে 96 করতে 1 বছর বাড়বে
2002-তে গেল তো
2002-তে এইটা দেখিয়েছে স্কুল
My lord, admitted.
পেজ 2003-এও গেল গিয়ে বললো আমার
বয়স আমার 97-এ জন্ম সেই অনুযায়ী সবকিছু হয়ে গেল
তাহলে ভুল ডিক্লারেশনে সব হয়ে গেছে
সব হয়ে গেছে
তাহলে ট্রুথ হচ্ছে তো
ট্রুথ হচ্ছে 1.96
কিন্তু ট্রায়াল কোর্ট বললো
গুলো মাধ্যমিক
এত বছর পরে এসছে shows the date of birth এইটা এই ফাইন it outweighs the evidentiary value of the hospital discharge certificate. Now, this observation 1597-এর সাপোর্টে কর্পোরেশনের সার্টিফিকেট
My lord,
Are you challenging the order on merit or only for cause? Tell us.
no, my lord, on merit also.
On merit. তাহলে tell us why the order is wrong.
My lord, my respectful submission would be, my lord, a person cannot have two birth certificates. Which one is the original birth certificate? As per the Birth and Death Registration Act, Section 15 empowers, my lord, to Section 15 empowers to cancel the, my lord, ingenuine one. If the ingenuine one goes, the difficulty will, my lord, be removed.
If
the what is not the genuine one, because a person cannot have two birth certificates of two different dates.
Yes.
As per Section 15 of the Birth and Registration Act.
Show us.
Yes, madam. I have one section.
বই নিয়েছে বড় একটা কি বই ওয়েস্ট বেঙ্গল লজ নিয়েছিল বার্থ সার্টিফিকেট ছোট
বইটা and the my lord,
any executed by him or form or as you fraudulently improperly made him a subject to such as corrected. এটা তো রেজিস্টার ইস্যু করে সার্টিফিকেট নয় এটা তুমি দেখাচ্ছ ওটা হসপিটাল that is in respect of a certificate issued by the registrar. This is hospital certificate.
no, my lord, this is registered. Issued by the Calcutta Calcutta Municipal Corporation.
Corporation, yeah.
Under the act.
Under that,
Under the act. By the registrar.
approach the corporation.
Register. By the registrar. Under the Birth and Death Registration Act.
না না ওটা নয় একটা ইয়ে দিন না
আচ্ছা তাহলে তো ঠিকই আমার সার্টিফিকেটে যেটা আছে সেটা
Page 70, my lord, will find, my lord, under section 1217, registration of birth and that this certificate has been issued.
So
So, my lord, which one is, my lord, right one? My lord, my lord, competent authority, my lord, municipal corporation.
where are the rules framed under
Yes,
this
my lord,
act?
I will refer, my
Any time period provided? Rule?
yes, my
5 years.
seven, Rule 12, my lord.
Rule 12.
12.
What you are doing now?
Right.
You are employed?
No, my lord, I am studying.
Huh?
Studying.
You are studying?
96 minutes. 31. 31 now. Yes.
Student.
We can send you to
Why
the
you have not approached the corporation?
to St. Lawrence ke approach করেছে?
My lord,
You want cancellation of their certificate? You are approaching the school. ঠিক করেছে কল।
Lord, I will. I single bench
In
judgment,
your
my lord.
pair, you
The judgment. Court has refused to exercise discretion.
My lord,
Why discretion has not been exercised? Since you have committed delay of 19 years. First. Second is,
my lord, wait.
you are arguing before us, come to section 15. The register can cancel. Who? Then KMC certificate register will cancel.
Yes, my lord. My lord, my lords can always my lord, ask for a report from the municipality.
What report? You have not approached him and at any time writ petition file including.
My lord, kindly have a look.
So what is the problem if we send it to you? You have no problem.
I tell your lordship what has happened. But their contention would find, my lord, in page 88.
My lord, I will speak for my contention.
No, Mr. We are saying we
Yes, my
will
lord. Whether your
send
lordship
it
will
to you.
even exercise that discretion, my lord, why I tell your lordship? My lord, he himself admit that there is one which is ingenuine, means forged. He admits. That is why he's asking for setting aside of one. There are two birth certificates. One has to be forged.
No, not forged. It may be an irregularly issued.
Now, my lord, what has happened is, in 2002.
Now, what stake do you have? You won't have to correct anything.
No, my lord, I tell your lordship why. Just 1 minute, lordship bears with me. When he came for admission to my school,
2002,
with a transfer certificate from another play school, it recorded 1997.
It recorded 90. Yes.
My lord, he would not have got admission in my school if it had not been 1997. Had it been 1996, he wouldn't have got it. So he took advantage of that wrong. If it was wrong, he took advantage. 1997. I've stated that on my affidavit.
That can be a ground for cancellation of that certificate.
But then he's reaped the benefits so many years. Then, my lord, admit card. My lord, students signed the admit card 1997. Mark sheet 1997. After so many years, perhaps some visa problem. I'm, my lord, visualizing. He says everything was wrong. Kindly, he is reaped the benefits. Would your lordship, my lord, permit such a writ petitioner any indulgence? Lordship will kindly not grant any indulgence. He has taken admission on the basis of that certificate, pursued his studies, appeared. My lord, kindly see one after another documents. My lord, kindly come to page 95. Quickly, my lord, I shall endeavor to run through all those documents. Kindly see 95.
All right, we come back at 2 p.m.
A fixed matter.
I have fixed matter before the Honorable Court number 1, my lord. Read bench, my lord. To sit, my lord.
কি হলো petition-টা? একটু দেখতে হবে because কি বলেছে
Same fact, my lord.
দেখতে চাইছেন dispute তো করতে দিন, দর্শককে দেখিয়ে দিন, হ্যাঁ?
They must override all the certificate that might have.
Well, from 95 onwards, all the documents where it's 97 mentioned, I've annexed. First is the transfer certificate in 2003, 97. Calcutta Municipal Corporation Health Department birth certificate, 97. The admission form of the school where father has mentioned, 97.
consider this judgment, Mr.
This one I'm sending.
Oh,
My lord, birth certificate is genuine, the word is, but here we have two. Here we have a two, and he has reaped benefit on the basis of one. I have it in my file. I have it in my file. Birth certificate is to be taken as sanguine. এটাই আছে আমার কাছে, আছে। Birth certificate has to be taken as sanguine. We have two birth certificates on which of the.
we understand that, but the thing is, proposition of law is that the birth certificate will be the genuine document, whatever date reflected that should be. We appreciate that you had been misled. You might not have got admission. If he had disclosed 96, you are saying you have reaped the benefit of that certificate.
But he has come to a writ court.
No, that you can agitate, Mr. If St. Lawrence School is incorporated in a dispute, subsequently, there is no linkage. We will record your statement.
Most humbly, I am submitting
we
it to
are
be putting premium on this dishonesty.
No, we will ask the registering officer to dwell on this head issue and pass
Yes,
a reason.
but just three or four documents. I'll trouble your lordship, my lord. 3 or 4 documents. Just 3 or 4 documents, and perhaps lordship would not. Quickly, I'll run through it. Kindly take from 95 onwards.
To be mentioned then tomorrow. Tomorrow Saturday. We have heard the learned advocates appearing for the respective parties.
20th.
ওই যে ভেতরে আছে।
I appear for the petition in this matter. But on the last occasion, your lordship directed that we should notify the learned advocate appearing for the opposite party state. So we have not, in respect, yes, Lord, we have not given a notice. আরেকটা কথা বলুন।
He appeared for state respondents.
The Shuddha Sattva Adok, I find, Lord, he has been notified. He was appearing in this matter. Shuddha Sattva Adok. তাই তো? Shuddha Dev. Okay.
Shuddha Dev.
Shuddha Dev.
Yes, Mr.
Lordship. Lord, I purchased, Lord, a chunk of land from Lord the auction sale conducted by this honorable court in the company side. Lord, it was a Hindustan Pilkington Glassworks at Asansol who was Lord operating a factory at Asansol for manufacture of glassworks. Lord, that company was wound up, and Lord, the land which belonged to the company, which the company got, Lord, by you of Lord, lease from Lord a private person, as well as Lord some portion of the land from the government by you of a lease.
They used opposition, Mr. Mukherjee.
No, Lord.
There was a deduction earlier.
Opposition. Okay. Yes, Lord, yes, Lord, it is there. Yes, it is there. Reply is also there. Yes.
Baba, এটা খুলে দাও।
That I want to argue.
Yes.
But the first date is Lord 23rd April 1954. But here, Lord, our concern is about Lord, the state is seeking Lord resumption of this land by saying that these are covered under section 6(3) of the West Bengal Estate Acquisition. My endeavor before your lordship will be to show that that particular section doesn't apply. So, Lord, the first Lord, the date that your lordship will find here is Lord that 1954, which is much before Lord the vesting date. First date is 23rd April 1954 in the list of.
Yes.
23rd April 1954.
3rd April,
And what the vesting dates are not 1st of April 1955 and not the 1st of April 1956 under chapter 6. So this 1954 registered lease deeds were not executed between one Gokul Kumari Devi and Hindustan Pilkington Glassworks Limited, whereby 38.61 acres. Kindly also mark the area of the land, because eventually your lordship will find that 56 acres are not the concerned area of Hindustan Pilkington, which my client had purchased. Was given lease of 38.61 acres of land with permanent mokrari right and right to build and use them in any manner. So as on the date when the lease was granted, it was not a factory.
It was not a
factory. It was a vacant land with a right not to build up a factory.
Now, my lord, on 15th of June 1954, a memorandum of agreement between Hindustan Pilkington Glass Works and the Governor of State of West Bengal for acquisition on pieces and parcel of land containing 13.86 acres, situated in the villages of Asansol and Kalipahari in the district Bardhaman for the construction of modern sheet glass factory and railway siding pertaining thereto. So, my lord, this area is 13.86, my lord, pursuant to the acquisition by the government. But this was also, my lord, in the year 1954. The said memorandum of agreement dated 15 June 1954 between Hindustan Pilkington Glass Works Limited and Governor of the State of West Bengal was published in the Calcutta Gazette prior to 55. Certificate recording that Hindustan Pilkington Glass Works received possession of 0.17 acres of land from Special Land Acquisition Office, Bardhaman, in village such and such, in accordance with the memorandum of agreement dated 15 June 1954. Further recording that possession of 8.20 acres of land was delivered on 24th August 1954 under section 17(1) of the LA Act. Possession of such and such was delivered on 14 June 1957 under section 16 of the LA Act, and also according to the possession of 0.17 acres of land was delivered under section 16 of the Act. Then, my lord, on 3rd of May 1962, the certificate of possession of such and such acres of land were given to Hindustan Pilkington. Then, my lord, 1963, indenture of lease between the Governor of the State of West Bengal and Hindustan Pilkington Glass Works for a period of 99 years from 24th May 1962 in respect of 6.725 acres and 0.33 acres aggregating to 7.055 acres of land in village Asansol, district Bardhaman. So this was in the year 1963, area is 7.055 acres. On 20th May 1980, a notice under section 6(7) of the West Bengal Estates Acquisition Act was issued to Hindustan Pilkington Glass Works, calling upon it to appear before the Assistant Settlement Officer and Charge Officer with all necessary documents to enable the government to determine how much the holdings are required for factory in terms of section 60 of the West Bengal Estates Acquisition Act 1953. So, my lord, the 1963, when the indenture of lease was executed in respect of 7.55 acres, so one part is a government leased property pursuant to acquisition. One part is, my lord, leased from a private entity that your lordship has seen in the year 1954. In 54, when the land was leased out, it was not a factory with a right to build up there. And in 1963, the leased property was in respect of a small portion of 7 acres out of that 56 acres. That was even after coming into force of the West Bengal Estates Acquisition. Now, the entire question will be, Lord, here whether section 6(3) could be applied here or not in the context.
Problem.
Now, Lord, in the year 1980,
State Acquisition Act. Mr. Manual try to change my party.
of Milord, the state of West Bengal. The state was a party there. Then, Milord, in 2001, sale notice was issued by the official liquidator.
Now, then what happened from 80 to 95? Nothing happened.
No, the proceedings were before this honorable court in a liquidation procedure.
Oh,
So I'll take your lordship to the orders. It went to the Supreme Court and thereafter it came back on the point of liquidation of the asset of the closed company.
Now, 95, these documents showing state was
aware of the fact that official liquidator High Court was selling the assets of the company in liquidation together with land. Then the sale notice was issued by the official liquidator. Then, Lord, the order was passed by Honorable Justice Ranajit Kumar Mitra, whereby the highest bid of rupees 4.25 crores of the petition number 1 was accepted and sale confirmed on 7th December in favor of Chaudhary Uddog Private Limited was set aside. That was not a competing bidder. Then, Lord, Honorable Appeal Court stayed the order dated 21st December confirming sale in favor of the petition number 1. The Honorable Appeal Court set aside the sale, which was confirmed in favor of petition number 1. Then, Lord, there were a judgment and by the Honorable Supreme Court to accept the offer of 4.25 crores made by the petitioner number 1 upon depositing the balance amount and directed the official liquidator to execute necessary documents in favor of the petitioner number 1. So I'll take your lordship to the judgment of the Supreme Court to that extent. Then, Lord, thereafter, orders were passed, my client had paid, and Lord, the property was handed over, and Lord, the deed was executed. I'm cutting short, Lord, the entire Lord, the sequence of events, which are not much of importance as
It was mutated also.
It was not initially mutated. The mutation was cancelled. There was another set of litigation concerning the mutation. Initially, it was mutated by the government. Thereafter, it was cancelled.
Yes.
Now, Lord, on 8th of September 2003, the date, Lord, at page 8 September 2003, there was an order passed by Honorable Justice Shubhra Kamal Mukherjee, whereby the official liquidator was directed to register 4 several deeds of conveyance in favor of petitioner number 1 and its 3 wholly owned subsidiaries, namely the name of the companies are there. Then then 20th December 2003, minutes of meeting was held at the office of the subdivisional magistrate in Kerala, recording that the petitioner will arrange shifting of the scrap from the old factory for subsequent construction from 21st December 2003. And if needed, the local police administration would render all possible help. Then, Lord, the record of rights, your lordship must have seen that, Lord, that portion, Lord, that. Then, Lord, on 26th October 2005, notice under Section 6(3) of the West Bengal Estate Acquisition Act addressing Hindustan Pilkington Glassworks was issued. So, Lord, it was in 2005 when, Lord, this notice was issued, whereas your lordship will find from the list of dates, Lord, that, Lord, the property has been, Lord, sold in favor of my clients, Lord, earlier there. আমাদের সেলের ডেটটা কত?
December 2021.
2003. But on 26th October 2005, that date, Lord, I am comparing with the sale when it was effected. Because the government knew about the sale. It was pursuant to the order of this court. And, Lord, at that point of time, also the Supreme Court. And in 2005, Lord, the notice is being issued to Hindustan Pilkington, the company which has been wound up under liquidation and the assets sold to my client. The entire, Lord, this 56 acres of land, your lordship has seen, were, Lord, sold to, Lord, the 4 companies which are owned by my client. As a whole. Then, Lord, Asansol Municipal Corporation, Lord, that mutation had happened. Then, Lord, there was a demand notice, and thereafter, Lord, the mutation happened, and thereafter, Lord, the mutation was not set aside pursuant to the order of this.
Mutation in Wellworth.
That is a petitioner before your lordship. The Wellworth.
Now, after 26th October, what happened?
But after 2006, Lord, there were, Lord, the correspondences going, and Lord, about the mutation. Purchase, mutation was cancelled. When I take your lordship to the orders, my lord, that
Now,
you have passed,
notice was 26th October 2005.
lordship.
Then
That was
what?
addressed to my lord Hindustan Pilgrim,
Hindustan.
not to us.
Then what happened?
Yes. Now, my lord,
You were called for a hearing.
lordship. Then your lordship will kindly 14th November 2005. Yes. But on 14 November 2005, there was a letter by the official liquidator in reply to notice dated 26th October 2005. So this was, my lord,
That notice was addressed to the official liquidator also.
but because he was in charge, because the company was in liquidation at that point of time. So, my lord, this was in, my lord, we have referred to in which page and which volume, my lord, the documents are there. That is, my lord, on the petition volume 2, page 298.
It was sold in your favor on
2003.
8 September 2003.
Lordship. Lordship.
Then why the official liquidator was in charge?
But because, my lord, the company was not
It had
entirely
gone
owned
down.
up. It was only the assets. Part of the assets were, my lord, sold to my company. There might have been other, my lord, assets of the company.
No, the 6-3 notice is pertaining to which quantum of land? The land which was sold to you. That is 51 acres.
56 acres.
66 acres.
50.
56. Yes, then official liquidator was
had replied to that, my lord, particular, my lord, the notice.
Then what happened?
Yes, and there was a hearing that had happened on 10th of January on 2006 that your lordship will find, Lord, at page 300, volume 3.
You have given the page number. Yes,
Yes, that is there.
hearing was one.
Then, Lord, the letters were given by the petitioner enclosing the orders of the High Court to contend that you cannot invoke the provision under 6.3 because I purchased from the court sale, and it was the state who was also endorsed the sale deed that was executed in my favor, and state had all through knew about the fact that it was being purchased by my client and participated in all the proceedings till the Supreme Court. Then your lordship will kindly come to 18th March 2009. But this was a letter by the petitioner inter alia stating that the proceeding under section 6.3 of the West Bengal Estate Acquisition Act was not maintainable and requested to proceed with the mutation. Lord, you will kindly then come to, Lord, the way that was filed, Lord, 13th of June 2018.
This way was filed for declaration that the provisions do not apply.
Yes. Now your
together with a prayer for mutation.
Lordship, page 148. And now page 148 of, Lord, the volume 1 of the paper.
Page 83. 13th of June 2018.
Yes, but Lord, I am on the relief claimed in the application.
Oh.
140. Page 50, 148 na, side e jeta lekha ache.
Doesn't, all right, that you have recorded
Well,
here.
Lord, it is saying type 58 or 148. Declaration that the provisions of the West Bengal Estate Acquisition Act has no application to the land of your petition. An order be passed directing the respondents to forthwith mutate the name of the petitioner number 1 in the record of rights in respect of the land of Hindustan Pilkington Glass Works in liquidation purchased by your petitioner number 1 pursuant to orders passed by the Honorable Supreme Court of India and the Honorable High Court at Calcutta, particulars whereof are set out in a copy of registered deed of conveyance dated 13th May 2005, being annexure K hereof.
Yeah, can you inform us as to whether the government pleader is in any court? If he is free, huh? If he is otherwise not engaged, just for 1 minute. Yes.
Then let an order of injunction be passed restraining the respondent to initiate any proceeding and or take steps under or pending proceeding under section 6(3) of the West Bengal Estates Acquisition Act to deprive the petitioner from enjoying the land particulars whereof are set out in a copy of the registered deed of conveyance dated 13th May 2005, being annexure such and such. In respect of Hindustan Pilkington Glass Works in liquidation purchased by the petitioner number 1, pursuant to orders passed by the Honorable Supreme Court of India and Honorable High Court at Calcutta in any manner whatsoever. Then, Lord, a prayer for quashing of Lord, the proceeding pending under the West Bengal Estates Acquisition Act. Lord, for mutation.
So, Mr. Mukherjee, the Supreme Court order which cancelled your mutation?
No, Supreme Court did not cancel. The Supreme Court, not so far as the sale is concerned, Supreme Court was of the opinion about the amount that was not directed to be paid. The sale was confirmed in my favor later on by the.
The mutation was ultimately granted.
Mutation was after not the sale.
Yes, mutation was
first allowed, then it was cancelled because.
Now, then what happened? Has that issue attained finality? No.
That has. But pursuant to the order of a single bench of this honorable court, the mutation happened. It was not set aside by a division bench to say that the company court did not have jurisdiction to direct a mutation of a property. I'm not taking the name.
Appeal preferred was dismissed.
Yes, and in the grounds of appeal, it was such that the company court had no jurisdiction to direct the mutation to it. So far as the mutation is concerned, it is still hanging. And the 6(3) proceeding, that is also a short which is hanging on my client's head, which prompted me to take out the OA application.
Now, after the division bench order as regards mutation, what happened?
It was reverted to the name of Hindustan Pilkington.
Supreme Court. In the name of a reverted to a company which has been wound up.
Because it was in the name of Hindustan Pilkington. Then it was mutated in my name. Then pursuant to the order of the court.
When was that order of reversion?
Yes, I'll give your lordship.
So you must have challenged that order again.
Yes, but that was without much success, Lord. That was. Now, page number. Page.
Thank you.
Supreme Court, yes. 237.
ও যেহেতু সুপ্রিম কোর্ট বলে দিল সব
mutation.
Mr. Siddiqui was appearing. It happens, Mr. Yes, Mr. Mukherjee.
So, my lord, your lordship was putting a query about the Supreme Court order, which is at page
Your
237.
list of dates tells us on 6th March 2018, the Supreme Court order was passed with a direction upon you to avail the remedies as available.
Lordship, that is at
After
page.
that order, you preferred the OA. No, Mr. Dotto, why we troubled you? For this reason, this is a quite contested matter, which Mr. Mukherjee moved. Affidavits were exchanged. Now it came up for it appeared earlier occasion also. We took time because nobody was ready. Mr. Mukherjee was ready. He was wanting. He was insisting. So we understand Mr. Siddiqui is no longer in the panel.
No.
So then
For quite
Mr.
some time, quite some time.
Then Mr. Dotto.
I'll see that somebody appears. My lord, lordship kindly adjust the matter for
No, we are. Huh?
well, service.
we will
I don't know.
engage-
Sub complete. AOAR sub complete.
Papers গুলো
If you can please check up and
appear করছি।
you can also appear, Mr. Dotto.
No, definitely I may appear. It will be my pleasure to appear before lordship.
That we don't.
Pleasure and also privilege. My lord, this I'll have to check it, my lord, whether the papers are available here or not. That's the first
We
thing.
can inform in a similar matter which my brother is hearing. We are another land matter. In that, Mr. Galib was there. Galib.
I know him. I shall ensure that at least yes, it's a land matter.
হ্যাঁ,
land matter শুদ্ধদেব আদক আছে।
ওর কাছে কাগজ আছে আমি দেখে নিচ্ছি। But kindly
Alright,
adjust the matter for some time, my lord. I shall ensure that somebody will definitely will appear. If not, I will appear.
হ্যাঁ, সেইটাই।
Mr. Mukherjee.
Lord, will kindly fix a date and time, Lord, because I'll not be
Time,
taking much
sir.
of half an hour, Lord. That will suffice. I'll be very brief and to the point, Lord.
ঠিক আছে। আজকে দিনে ঝামেলা অনেক
অ্যাসাইন্ড এই দেখো তো অ্যাসাইন্ড হয়েছে কি আবার সেই অর্ধেক
কোন প্রমোটার? 7, 8 আর 15 প্রমোটার তো ফিরে গান দিয়ে
সে পারবি ঠিক পারবি এই মর্গেজ দিয়ে ব্যাংক ওটাকে এরই যেটা ছিল এটাকে এটা তো মানে অন্য নাম দিয়ে এই ছিল
এই ম্যাটার শ্যাল বি ওইটাতে ইয়ে করে দাও।
প্রতিকান্তকে ডাকো। Yes. No, my lord, in this public interest litigation, my lord, the petitioner complains of large scale of irregularities in sanction.
Large scale of
Irregularities in sanctioning the building plan by the Sirampur municipality. Now, my lord, before placing the matter, I must say, my lord, that respondent number 4 to 13 and 16 to 21, who are the basically, my lord, the developer. There, my lord, the service returned with an endorsement that no such person in the address, because we find their address from the software of Opus. Opus means, my lord, now the centralized sanctioning software, my lord, which is maintained by the Department of Urban Development. From there, my lord, from that software we find the address. But my lord, when we post the serve, my lord, the copy of the application, those were returned with an endorsement, no such person in the address. And 4 to 13 and 16 to 21, they are basically, my lord, the private respondent and the developer.
what happened? Construction made or continued?
My lord, what happened, my lord, the construction made.
Now, who are you appearing?
My lord, I am appearing on behalf of the chairman.
So, chairman of the municipality. You are respondent number?
Number 3. Respondent number 3.
Chairman.
Yes.
And who is for the state? You state who is
My lord,
appearing?
lordship has possibly noted, my lord, he has not implicated the, my lord, the municipality as a party.
Acha, দাও না বলছি। Chairman Sirampur is there.
Yes.
You are there. What is the requirement of
My lord,
municipality?
I am a chairman. Lordship knows the, my lord, company laws far better than I do, my lord. A director and the company cannot be clubbed together. Similarly, on the similar contest, the chairman and the municipality.
So there has been an illegal construction.
No, my lord. My lord, may I show your lordship if the contention of the petitioners is something different.
Wrong. You are right. He is not.
I'm just, my lord, requesting, my lord, to consider only one paragraph of the writ petition.
No,
which
no,
is paragraph
paragraph
11.
come later. First, what about which private respondents you said? 4 to
4 to 13, 16 to 21.
4 to 13, 16 to 21.
Yes.
Now 14 and 15 is represented.
I beg to appear on behalf of 14 and 18, but we have
14 and
18.
You are for the respondent number 12. Then you got service.
No, my lord, my
Yeah, you
envelope
said-
returned.
Huh?
My envelope returned with an endorsement, no such person in the address. Yes,
Very
they
good.
were served.
But I will definitely take the point of maintainability.
19 and 20 possibly died, my lord. They are
7, 8 and 15.
They are the owner or
the owner, my lord.
Owner.
14 and 18
owner?
You are all the persons who are appearing are all owners.
14 and 18 and
And who is the or is or are the developers?
And you are also you are the Visheshwar Das. You are the developer. One of the developers. And you and you are also for 15. Developer. And who is for this 16? Anybody is appearing? 16, 17, nobody is appearing. So when you are the developer, you don't know who are the other developers. Must be knowing. Huh? One man came to your chamber or many people came to your chamber? Oh, one man. So you didn't ask him who are your friends? No, we are asking for the
Where
others.
is your
Lordship is
development
giving them
agreement?
an idea to become enriched.
Where is your development agreement with the owner? You produce the same development agreement, will say who are with you.
Yes. Very good. But when you are a developer, you are one of the developer. So you bring us that development agreement. Ah, right. My brother wants to see the development agreement. And you are the owner. So you please all bring your development agreements. We shall ascertain.
Yes.
Whoever is appearing for the developers, and you are the owner.
Only one indulgence, my lord. Section 11 application of under Right to Information Act is pending before the municipal authority. They are processing it. Meanwhile, this writ application under the, my lord, the public interest.
What is section 11?
11, my lord, third party information in terms of the Right to Information Act.
It is barred.
It is, my lord, third
part.
Third party.
That is another aspect of the So, Milord, may I say?
That
Well,
is not
they are-
hard for us. We can ask for the
Certainly not,
development.
but the municipality is in Sessin. My lord, 284 may kindly
Supreme Court or board.
285.
Let the municipality be in CC.
May I?
He will dismiss the petition if he cannot.
Yes, I will be arguing on that point only. Because once he has taken the recourses of the right to information and
Right to information only to get certain information.
that's it, Milord. Lordship is absolutely correct. This information, Lordship would find at page 284 of the P6. That is their requirement. Now, Milord, Lordship would see, Milord, the answer is on 285. Milord, the municipality has categorically stated this is whatever you are asking for is falling under the prohibition zone of the section 11. So he has chooses not to go by the appeal, which is the statutory appeal. Lordship knows the Satyavati Tandon and others, which is the one of the statutory appeal is there. Once he chooses the recourses of the right to information, he has to go by that. He has chooses not to go by that and invoke the writ jurisdictions and invoking the same, renewing the same prayer which he has sought for before the municipal authority. My question is that, Milord, once the prohibited, it is always prohibited.
Whether he is seeking any direction from us upon the municipality to furnish the information.
No, my lord, kindly appreciate one thing. Kindly
So
take
that is a separate cause of action.
it is not a separate cause of action. Prayer A, kindly see the prayer A.
Prayer B.
Prayer B. I'm sorry, prayer B.
Only prayer.
Some are strong, my lord. Commission is also there.
Kindly see the prayer B.
Kindly see prayer I.
Prayer I. Prayer I. Read in the nature of mandamus, past directing respondent, each of them to cause demolishing the construction pursuant to the. Well,
So this is a, let us understand.
This in that event, may I
No,
suggest?
Mr. Ghosh, let us understand. We make several prayers in the writ petition.
Right.
Your argument is section 11 we have replied, they have not taken further course of action. As such, they cannot come to the writ court again.
Lordship is
But
absolutely
when he has approached the writ court, suppose he is claiming any relief against you.
yes.
You have been made a party in this. If he says that avoiding the statutory provision which is there,
Exactly.
he can come. If he comes, that is barred.
That is what
your
I am
argument.
saying.
For that does not, for the entire writ petition has not to be thrown off. We will take into consideration.
No,
Maybe
Lordship-
we will ask you, no, Mr. Go, you don't have to give any
No,
information.
Sengupta, Milord.
Sorry, Sengupta. We will ask not to give any information.
No, Lordship kindly hear him, but the point of maintainability of this petition has to be heard by your Lordship as per my understanding.
Where
Because
we will,
he is
we are
simply,
able
no,
to-
Lordship kindly appreciate this much. He is
where
simply-
we will go, we will hear,
Definitely.
hear Sengupta also. Yes, when can you bring your development agreements? Tell us.
2 weeks, wait.
We have not decided, we are not we are asking, we will only call for these dogs.
Contested election as a MLA candidate of the area, thereafter as the MP candidate of the area, and wants to use this to hold hostage to the people of the area and make sure that we can address the future issues. What's not from public investigation of our submission is how a political force in the guard of the public. I can draw your definition. Because with regard to the public
Where Lordship was indicating the paragraph, prayer I.
মানে পার্টিটা ইয়ে হয়ে যাবে প্যারাগ্রাফ 3 অফ দ্য আছে না আছে বা বলতে পারছে না কে মারা গেছে কে ইয়ে গেছে ডেভেলপমেন্ট এগ্রিমেন্ট হলে পার্টিটা আছে কে ডেভেলপ করছে আর কি
No, speak of many properties.
তো অনেকগুলো আছে
একটা টিতে বলছে না আমি কে
এর যে কটা ডেভেলপমেন্ট
ওর বক্তব্যটা পলিটিক্যালি পলিটিক্যাল কোনো ইস্যু তুলছেন
May I take your Lordship to only one thing? Lordship has pointed out the prayer I. Prayer I. Now, kindly take trouble to see because
sir, we will keep your
no, my lord, kindly hear me
point
because
your maintainability point
no, because Lordship is
without-
speaking, my lord, Lordship is
without
direct. I understand.
without exhausting the alternative remedy he has approach.
Correct.
It is here. And it is here, it cannot be treated as a public interest litigation. And this litigation is being used for to gain some political advantage.
And that
And for this cause, this is cannot be treated as a public interest litigation. Okay.
in addition with, there is another point.
Yes.
Assumption and presumption. These two are different.
Okay. So the petition has been filed on the basis of assumption.
Assumption.
It is at the time of merit.
Maintainability.
You are
I will be pointing out. Has to be decided first, my lord.
নাম্বার গুলো নিয়েছো কে কার জন্য অ্যাপিয়ার করছে
আচ্ছা হার জ্বালানে
নেই হ্যাঁ কি in person আছে নাকি? আগে আন্দোলন করো কি আন্দোলনের কি আছে তো তো এই আছে যখন একে শুনে নি ইন পার্সন অ্যাপিয়ার করছে একটু দাঁড়াও আমি একে শুনে নি ইয়েস
মাই লর্ড, ওই সি সি প্যানের আপনার ঘরে সি প্যানটা ছিল, তো অনারেবল জাস্টিস
নিচে ওয়েট করো ও এইটা রিটেন অর্ডার আচ্ছা হ্যাঁ ইনিশিয়াল সিন্স সিটিজেন হ্যাঁ তারপরে ক্যানটা সমেত সেটা আবার রিকল করো না বলছি যে ও আচ্ছা আচ্ছা এখন কন্টেম্প এসছে ইউ আর ফর হুম
My lord, Lordship kindly see my lord, 19th September order. There was a specific direction my lord, to serve the copy of the contempt application. As on date, no copy has been served. I appeared last occasion.
You appeared.
Yes.
Now he has given a copy to you.
No, Lordship direction was there since I'm recording your presence, but let a copy be served.
মাই লর্ড,
Same thing happened in case of other recalling applications, other coordinate bench. Honorable court recorded an order. If you do not serve, I will dismiss your application. Only then copy was served. And matter was ultimately disposed of by Honorable Justice Mantha.
Acha, what was the which order he alleges?
Well, I do not know anything. My lord, copy has not been served.
মাই লর্ড, এই যে সি প্যানটা মাই লর্ড আপনার ঘরে ছিল, তো ওইটা জজ সাহেব রাজাশেখর মান্তা জজ সাহেব, মাননীয় জজ সাহেব, ওটা দেখলেন যে এই সি প্যানটা আর খুব একটা ভ্যালিড থাকবে না। উনি ওখান থেকে অর্ডার করেছেন একটা মাই লর্ড, সেখানে ওই সি প্যানটাকে আর রাখছেন না উনি। আর হচ্ছে ওই
আপনাকে যেটা বলছি বুঝতে পারছেন না
হ্যাঁ।
কন্টেম্পট অ্যাপ্লিকেশনটা কোন অর্ডারটাকে আপনি তার এসেছে আপনাকে তো কপি সার্ভ করতে বলেছিলাম আপনি করেন
আমি ডি অফিসে গেছিলাম, বললো যে কপি ওনারা পেয়েছেন। ওনারা
কার্ড অফিসে গেছিলেন
হ্যাঁ
কার্ড অফিসে গেছিলেন
ডি অফিসে বললো তো ওই আমি কপি সার্ভ করেছিলাম আগে মাই লর্ড, সেই কপিটা ওনারা পেয়েছেন।
19 পরে কপি দিয়েছেন
19 পরে গেছিলাম মাই লর্ড, বলছে যে কপি সার্ভ আমরা পেয়েছি, আগের কপিটা
কে বলেছে
ডি অফিস থেকেই বলেছে মাই
কে
লর্ড, ডি অফিস থেকেই বলেছে কপি সার্ভ আমরা পেয়েছেন, আর লাগবে না, তাই জন্য আমি আর মাই লর্ড দিইনি কপি সার্ভ। তো আমি গেছিলাম,
তো ওনাকে দেননি কেন
ওনাদের কপি সার্ভিস করা হয়েছে মাই লর্ড।
Let the proof be given. I have taken instruction, my lord, only few minutes back. Headmaster, my lord, specifically gave a message. I have not received any copy.
যদি কোর্টের অর্ডার শুনে না কাজ করেন না ছুঁড়ে ফেলে দেওয়া হবে কোর্ট শুনছে বলে বেশি ইয়ে হচ্ছে
My lord, I appear on behalf of the contemners, my lord. I filed my compliance report, my lord. We have complied the order.
Comply.
My
As per the petitioner, my lord, I have filed the exception, my lord. I have filed the exception because, my lord, they are saying it's an excess land is there. But, my lord, the entire land.
Have you given a copy to your friend?
Yes, my lord, I have given with.
My lord, if my lord sees my compliance affidavit of compliance filed on 24th September 2025, my lord, I have annexed a report, my lord, wherein it is indicated, my lord, this writ petitioner is in excess land, my lord. So, my lord, there was a direction for demarcation and we have done the demarcation, and from that demarcation we came to know, my lord, that the writ petition is in excess possession, my lord.
All right, please give me a moment. Let me go
My
through.
lord, my lord, my lord.
কোথায় ওর এই কমপ্লায়েন্সটা দিয়েছে ওটা কোথায়? কোথায়? Yes, so your inspection was conducted with prior notice.
Yes, my lord, and they were present also, my lord, in the spot.
Where do we find that? My last order was that Ms. Das submits that the concerned demarcate upon serving notice to the concerned parties and by fixing a date on 6th.
My
And
lord.
basis of such demarcation, on 6th May, the SDO has passed the order of 22nd July.
On the basis of the report dated 19/5/2025, which I have annexed along with my compliance, affidavit of compliance, my lord.
To know where is the Tehsildar's inquiry report. On 6th May, if you had conducted an inquiry with upon prior notice, where is the notice and where is the report?
My lord, report is that I have annexed with my affidavit of compliance, my lord.
You have annexed?
Yes, my lord, I have annexed report dated 19th May 2024.
This
Sorry,
report has
25.
this report has been filed by whom?
By me, my lord. By surveyor.
19th
19th of May 2025, my lord. The inspection was done, the demarcation was done on 6th May 2025 upon prior notice of all the parties concerned, my lord, and thereafter a survey report that was
just wait, madam, look at notice dated 28/25. So you conducted an inspection on 6th May by giving a notice on 28th April.
My lord.
Now, in the signatures are what? Signatures, they were present. So, on the basis of 6th May inspection, this report was filed, 19th of May.
My
Is
lord. My lord, this is the demarcation report, my lord.
Which one?
19/5/2025, my lord.
Yes, then
The demarcation which was conducted on 6th May 2025, in which we, from ETS machine, it was conducted, my lord.
What was it?
And, my lord, the finding of the demarcation report
On what basis? What did you say? What basis?
on electronic total station machine, ETS machine.
Where do we find that?
In the report itself, my lord. In the
You-
second paragraph of the report, my lord. In this connection,
Oh, I see, I see.
physical possession of the subject land.
Yes, Miss Jeannie, they have filed they have done the compliance.
My lord, kindly see, my lord, what they have done. They have not given with the notice to me. That is there, my lord. Notice not to me or to my any person.
Your signatures appeared in that list.
No, my lord. No. And moreover, my lord, what they have written, 1, 2, and 3 paragraph, kindly be seen. I have encroached a land. I have encroached a land. I have not encroached any land, my lord. Kindly see the survey numbers, my lord. The survey numbers which the
We give you liberty to challenge the main order. What is your problem?
My lord.
My lord, but my lord, kindly see these persons. There is no government revenue land. They are saying it's a government revenue land is there.
That is a dispute, madam, to be considered in an independent writ petition.
My lord, these survey numbers, they are the close relatives.
You are not understanding what I'm saying. Please answer my query. I have put you a question that there was I passed an order because you submitted that on 6th May there was no inspection.
My lord.
We are passing the order on the basis of an earlier report of 22nd January 2025.
My lord.
Upon considering your submission, I asked Ms. Das to produce the demarcation report as well as the final order. Final order was given. Now, the demarcation report shows that the notice was served and on the basis of an electronic total machine, station machine, this was done.
My lord.
Now, you are alleging that I was not present.
My lord, I was not present, and moreover, this excess area which they have said in the report, that is not there, my lord. From where they got all this, I don't know, my lord. Because kindly seen the second and third, 665/1 and 665/2. My survey number is 666/1/2. All these survey numbers, we all are close relatives, my lord. Where is the question of excess area, my lord?
You have the notice which you issued on 6th for the inspection. Do you have that?
No, I have not received.
No, madam, miss.
No, my lord. Presently, I don't have that notice, my lord. But it was served, my lord, and on that basis only it was done. And
it was when it was served, you must be having that notice signature of this person. Finished. You bring that notice of 28th of April 2025.
My lord.
First line, madam, kindly see.
Yes, my lord. This is with reference to the notice dated 28/4/2025 received from the Revenue Inspector 2 regarding demarcation of land bearing survey number 666/1/2, area measuring 0.0579 hectares situated at Phoenix Bay Village, stands recorded in favor of Shrimati Khurshid Begum.
Right.
That's the writ petitioner.
This connection, physical possession of this.
Possession of the subject land and adjacent plot was taken using the electronic total station machine on 6/5/2025.
Very good. You only show that you gave a notice which they received.
My lord.
That is what I asked on the previous occasion also. Where is the notice
Lord,
which?
if we serve also, my lord, they refuse to accept it, my lord. That is the problem. I will just inquire from the authorities, my lord, what they have done, because this report is there and it's a field inspection report, my lord. On the spot only it was prepared. That's why all. My lord.
Your report refers a notice date
28/4/2025, my lord.
that was received from the revenue inspector.
Yes, my lord. That the surveyor has received, my lord, the notice.
Then my order was that you give a prior notice. Did you give a prior notice?
Yes, my lord. In the order itself, it is there, my lord. If my lord sees the next page, 15 July 2025 order, my lord.
Yes.
1, 2, 3. Fourth para, my lord, and fourth para, and whereas notice has been issued by the revenue inspector, circle number 2, for demarcation of land bearing survey number 666/1/2, measuring area such and such, situated at Phoenix Bay Village, to all the concerned parties by fixing the demarcation date on 6/5/2025. My lord, in the order itself, it is reflecting, my lord.
No, she alleges that no notice was served. If we find that notice was served, Miss Ginny, you will be in problem. I tell you, you are unnecessarily wasting court's time making a statement. If I find that it was served, you will be
It
in
was
problem.
not served to the petitioner, my lord.
Very good.
It was not served to the petitioner.
Pursuant to the earlier order, Ms. Das, learned advocate appearing for the alleged contemners, has filed a compliance, has filed an affidavit of compliance. Stop. Miss Miss G.
My lord, I have the copy along with me, my lord, and her signature is also there. I'll annex. I have the copy.
You have the copy. Show it to me. Can you show it to her?
My lord.
Yes, then check up.
My lord, this is the original notice, my lord, which was served to Khurshid Begum, Sebastian and other adjacent plot holders, and her signature is also there, small signature along with phone number. This is the original notice. Let ask Miss Mini that this is the original notice.
Miss Das, you do one thing. You send the notice which was given.
My lord.
Please, we are keeping it on the next date.
My lord. My lord.
My lord.
Yeah. To which an exception has also been filed by Miss Mini, learned advocate appearing for the petitioner. Stop. Miss Mini submits that no prior notice was issued. Miss Das prays for an accommodation to produce the notice which was served in terms of the order of this court for conducting an inspection on 6th May 2025.
Notice dated 28th April 2025, my lord. I have this copy. Original copy I have.
Miss Das ki bolle? Prays for an accommodation to produce the notice which was served prior to demarcation on 6th May 2025. All right.
Copy may be served to me also, my lord. The notice which there.
Then they'll say, my lord, that they have not received. It is not their signature. All these things, my lord, they're delaying this matter, my lord, unnecessary. Yes,
Why
it is
delay?
original. I have, my lord, and
If
their
you
phone
give-
number, their signature. Now they'll again
I
they'll
can
say
ask my
that
client. I
it's
can
not
ask my
my
client. I can compare
signature.
with client signature.
If they have, you only show us that the notice was issued, you
My
guess
lord, my lord.
of the notice.
Yes,
And then whose counter signatures were there
my
in
lord,
which were placed.
my lord, my lord.
In view thereof is the matter. This is you are delaying your own issue, and if I find you are making a false statement, you would be in a problem because this contempt is being dragged for a substantial period of time. If I find from the notice served, then it's okay. Now you will be having the difficulty. A copy the December. করে দাও।
A copy of the notice may be served to me also, my lord, if what they are filing it.
You have been served the notice, they are saying. Miss Das,
My
if you
lord,
you can make a Xerox copy of that
my lord,
notice,
my lord,
But
I'll
copy
serve.
can be given to me, my
I'll
lord.
serve.
give a copy to her or be prior to the next date. We are keeping it on 12th of December.
My lord,
Right,
my
my
lord.
lord.
Who is into?
My lord, Mrs. Nag appears for the writ petitioner, my lord. This has been complied with, my lord.
Your Lordship, my senior, Mrs. Anjali Nag, she appears for the petitioner.
Where is she? Oh, order has been complied.
Yes, my lord, order has been complied with.
Miss Das, learned advocate, appearing for the alleged contemner. Contemner or contemners, Miss Das?
My lord, contemners, I believe. My lord, contemner, my lord. Only Tehsildar.
Ms. Das, learned advocate appearing for the alleged contemner, submits that the order passed by this court in the writ petition has already been complied with.
Fine.
Such statement has not been disputed. Madam, what is your name?
Your Lordship, Sohini Biswas. Sohini Biswas.
Purnima Bishwas.
Sohini Biswas.
Sohini Biswas.
Sohini Biswas. Not been disputed by the learned advocate appearing for the petitioner. In view thereof, this court is not inclined to proceed with the contempt application any further, and the same is accordingly disposed of. Yes. 5th December, you come with the calculation and note that period.
No, my lord, if your lordship kindly see the order dated 12th November 1, paragraph 8. Lordship kindly see, my lord, as to whether present contempt petition is now.
We will consider
no,
that.
contempt petition has been disposed of.
No, that has been deleted, corrected by a subsequent order. This order. You please kindly come and tell me, Mr. Chattopadhyay, whether we issue two direction, whether for that date period school has paid, and as to whether after he has been transferred, it is no longer your responsibility.
Yes.
So you please only intimate me whether the salary for that period has been paid.
Discussed.
No, my lord, completely not been given, my lord.
All right. Had Mr. Raju Eh?